plus but it's my the caddy corner shot was where I assumed the caddy corner shot is where I assumed it was going to be. That yeah, we'll just see. I mean, it's this where I am now. They need to not let us be, and it's in my opinion the only place it's not a bus. Remember, caddy corner. About let them know that whoever that, let them know that such a cool bear.
details that are spoken within the call itself. For instance, Mr. Murphy, having told her that his girlfriend was 8 months pregnant, he references her pregnancy on the phone call. He references times that he will have to go to court. He references things that he is charged with. And as for Mr. Allison and Mr. Stevens.
Let's go to that one. Tell me how the statements are, you're going to exclude the home invasion or anything, any statements as it relates to that.
Right.
The rest that's left, how are those statements in furtherance of the conspiracy?
Thank you, Your Honor. As we laid out for the court and counsel for the defendants yesterday, the first portion of the call, after they acknowledge one another, Mr. Stevens and Mr. Allison, and after they get out of the way, that home invasion stuff, you hear Mr. Allison in a very guarded voice telling Mr. Stevens that your man, Lil D, you need to do something about him. And you hear Mr. Stevens saying—
Who's Lil D?
That would be Quindarius Zachary.
Okay.
Who incidentally will be called as a witness in this case, but that has no bearing on this fact. Quindarius Zachary is also a person who has been identified as a member of the criminal street gang, Young Slime Life. He is also a person who entered into, was convicted of events that occurred in the wake of Donovan Thomas's murder. He was an alleged he was a straw purchaser for members of YSL. So he is very firmly established as a YSL member. What he is doing is now conversing with Mr. Allison about, what Mr. Stevens is doing is now conversing with Mr. Allison about the fact that Quindarius Zachary is talking. He's telling on folks. And Mr. Allison is encouraging, to say the least, Mr. Stevens to talk to Quindarius and get him to stop talking about these events to the police. That in itself, Your Honor, is a conspiratorial act and statements, considering the fact that these events, he also references later on, they're locking up everybody. They have locked everybody up. And then you hear Mr. Stevens say, no, they've only locked up 2 people. They also reference Montunk along with Lil D. So at least 2 members of YSL had been charged with offenses, including gang activity in the wake of Mr. Thomas's murder. And they are discussing that and discussing how to mitigate the impact of one of the members' willingness or apparent willingness to speak to the police about that. So our argument is that the conspiracy that is the existence and operation of the enterprise in the criminal street gang, Young Slime Life, is one that has been charged. And the conversation that they are having regarding quieting Lil D and not having him speak anymore to the police is yet another conspiracy that furthers the interest of the gang itself. And that is, these are all done during the concealment phase of this conspiracy. And in fact, the majority of the call between Mr. Allison and Mr. Stevens has to do with that. And there's also a point at which Mr. Stevens, during that call, asks Mr. Allison if he believes that, I think he called him Rapper Boy, would be amenable to helping him out, paying his bond. Mr. Allison responds, I don't know. If he does, if he is willing, he hadn't talked about it. And if he does, it'll be in secret. So Mr. Stevens on the stand presented himself as a person who had no further ties with the rapper. I believe that they are speaking of is Jeffrey Williams, that they went their separate ways, that he was jealous of him. This is what he said on cross. He was jealous of him because he made money, but he expresses no such sentiment while he is speaking with Mr. Allison. And in fact, he is speaking with Mr. Allison in a more hopeful tone. that Mr. Allison will reach out to yet another member of YSL, as the state alleges. So the entirety of that call, with the exception, just for the sake of argument and for the purposes here, with the exception of them discussing the home invasion, are co-conspirator statements that relate to the offenses charged in count 1 of 22 SC 183-572.
All right, madam. Mr. Steele and Mr. Shart, you may now move to, let's do the Walter Murphy call to Erica.
I don't know if it's ever been established. Maybe I missed this. What dates does anyone know what dates these calls were placed?
Yes, so the one to Mr. Allison from Mr. Stevens was placed on August the 1st of 2015, as my memory serves me correct. And the one to Erica was placed, I believe, on July the 15th, the day that Mr. Murphy was arrested at Mr. Williams' home.
That answer your question, sir?
It did, thank you.
Okay, all right. Mr. Steele, you may now turn to the call between Mr. Murphy and Erica from 15 July of 2015.
And before I do that, with the court's permission, there's one other portion that I'd like you to consider, if you're admitting it at all, to also order the state to redact. Mr. Stevens is talking about the fact that he has a choice of taking probation, jail, or going to prison for aggravated assault on a police officer. So he is going to take the probation. So I don't see how that furthers the conspiracy either. But that is on the original recording that we were just talking about. Mr. Stevens / allegedly Mr. Allison.
So what are you objecting to? Relevancy or what?
Does not further, yeah, of course. It does not further to say that I've already chosen, I had options, jail, prison, or probation. I chose probation about aggravated assault on a police officer. I don't know how that can possibly further a conspiracy. That's just a statement.
I understand. All right, madam.
Your Honor, I believe that that portion of the conversation gives greater context and detail to the remaining portions. Mr. Stevens, as we all know, has testified about, and we've entered into evidence, the incident that he's speaking about. So we would ask that the court allow us to keep that portion in as it provides reciprocal and integral context. They are reciprocal and integrated utterances that tie into the rest of the call that is taking place. He is sharing with Mr. Allison his intended outcome of events that are, we would argue, a part of this conspiracy overall. So, but he's just talking to him about it. And it shows his level of trust and relationship with the person that he is talking to. And we believe that that information would be relevant to the jury's consideration of the call overall.
I don't think so. I'm going to exclude it.
Okay.
All right, so you can exclude him talking about probation, jail, and prison, okay?
Yes, Your Honor.
All right, okay. Anything else as it relates to the first call on August the 1st of 2015 in terms of what the court has enumerated?
Not other than what we said, Mr. Stevens not on the stand, foundation, all the, it's not co-conspirator hearsay, but
that's what you're saying it is. I understand your argument. Okay, all right. Let me hear argument on the Walter Murphy call on July the 15th of 2015.
Okay, so Your Honor, here is a sequence of the call. I have to get you timestamps for some of this, but I agree that Mr. Walter Murphy is in what I consider the booking process at the Fulton County Jail. It's recorded He is crying to a woman, clearly talking later about she's about to be a mother, so I assume it's his significant other. He states he never woke up this morning thinking that he'd be charged with, he says, murder. That's at 1:59. I don't know how that furthers the conspiracy. He states they want me to tell. I'm going to tell you everything. I don't know how that furthers the conspiracy. That's spilling the beans. At 2:40, he states, we got to ask Thug to start a fundraiser or something. I got to get some money. It's through 408. Having a fundraiser does not show a conspiracy just because he knows Jeffrey Williams. He then states, should have listened to Birdman, told me there ain't nothing out there but trouble, bro. I don't know how that furthers a conspiracy that he has regrets not listening to someone. He's crying again, Your Honor, and he wants somebody to watch over Erica. It's through 7:01 or 5 minutes, sorry. I don't know how that furthers the conspiracy. He then at 7:01, Mr. Murphy, states, we got to start a fundraiser or something, got to get some money so I could pay a lawyer. I just think that's a fact.
Excuse me. Sorry.
I just
All right.
think that's a fact. He's making a statement of fact, not furthering conspiracy. 7:13, because they got me in the car with people on camera, but they do not have me shooting on camera. God bless you.
Sorry.
Do you see what I'm saying? Doing the shooting, the person is not dead. He just brain dead. See what I'm saying? That's from about 7:13 to 7:42. I don't know how that furthers a conspiracy to say that the person is not dead but brain dead, and they have me on camera, but not doing the shooting on camera. That is, in my opinion, spilling the beans. He then states that they're going to have to put a metal plate in his head. Your Honor, in context, I believe it doesn't say it directly. They're talking about Mrs. Dexter Montgomery. I don't know how that furthers the conspiracy. Then it goes on.
Well, haven't they, I'm sorry to interrupt you, but hasn't the jury already heard from Mr. Montgomery saying he's got a plate in his head
I think so.
when he's on the stand?
I think so. I'm talking about this call, though.
Okay, all right. So, all right,
I believe that's true.
okay.
They want me to tell, bruh, you know what would happen to me if I do that right? I don't know how that's furthering a conspiracy. That is spilling the beans. It's at 9:08, at 7:46 to 9:08, somewhere in there. Then he says, I listened to Dolly, then I listened to my mama. Dolly was like, you know, and then I'm not 100% sure what he's talking about. But he's talking about something about getting an apartment. I was just listening to them when I shouldn't have. Then he has an argument with Erica, and she says that she's got hurt feelings. That's at 10:48. I do not believe that advances the conspiracy. And then he curses and says that SHI blank is so F blank CKED up, like even with Thug just getting locked up, and the only person I could think of was you. Then at 10:59, Mr. Murphy says, but Thug, he's locked up. He got all this SHI blank in his house, which is the suppressed evidence. So we moved to exclude that as well. And then he states at 11:15, either we're going to try to talk to Thug, and I'm just going to ask him straight up to start me a fundraiser. You know what I'm saying? And Dora, who, Your Honor, Dora, by the way, they spell it. Some people spell D-O-R-A. That's not the correct spelling. That's how it's spelled in a lot of the transcripts in our case. Dora or somebody like that can be over it. The only way I'm going to get out, all this is my fault. You're going to be the perfect mother. Erica states, why don't you call somebody else? Mr. Murphy says, I don't want to talk to nobody but you. That's the entirety, I believe, of the statement. And I don't understand how any portion is furthering the conspiracy, including we have to ask Thug to do a fundraiser or something. So that's my objection.
All right. Ms. Love? Yes, you can, Mr. Matthews.
I'd like to cite to the court State versus Wilkins. It's going to be 302 Georgia 156. Basically, it lays out that a retroactive statement regarding matters that have already occurred and that is not intended to foster involvement in the conspiracy is not a statement in furtherance of the conspiracy, and a statement that merely spilled the beans to a third party can hardly be considered to have advanced any object of the conspiracy. Similarly, a statement which was not made to conceal the conspiracy and served only to disclose the scheme, or which merely informed the listener of the declarant's activities, is not admissible. And that's under 801. And that's State versus Wilkins, 302 Georgia 156. Thank you, Your Honor.
What year was that, if I might ask?
You said Wilkinson is 302 Georgia 156?
Yes, Your Honor. It's a 2017 case.
Okay.
Thank you.
All right. Mr. Sharp?
I think Mr. Matthews covered it.
All right. Okay. All right, State. How is the call to from Mr. Murphy to his significant other in furtherance of the conspiracy?
Your Honor, I made a distinction in the purposes for the two calls. Mr. Murphy's call to the person Erica is an impeachment by contradiction. Mr. Murphy on the stand said a few times, as I stated earlier, that he had no contact with Jeffrey Williams. He did not get financial support for him. He did not expect for him to pay his bond or help him get out of jail. In this particular call, he is expressing to Erica a completely different sentiment and expectation, and that is that Erica reach out to Jeffrey Williams and give Mr. Murphy a fundraiser. Additionally, Mr. Murphy, in the July 15th interview with Detective Gaither and Detective Edwards, feigned a lack of knowledge to a large degree about events that occurred on the night Dexter Montgomery was shot. With Erica, he speaks much more fluidly, clearly. During his testimony from the stand, Mr. Murphy said that he would have said anything to get out of jail, that he would have chopped off his arm to get back to his children, and that he was so high he didn't remember anything. And his words to Erica made quite clear that he very much remembered what happened in April. He talks to her about the fact that they have him in the car. He talks to her, giving her way more specifics than I think he had actually offered to Detective Gaither or Edwards, and certainly more than he gave to the court or to the jury during trial. So the first portion of what we're offering the call to Erica for is impeachment by contradiction under 622. The inconsistent statement that we spoke of was his statements regarding Jeffrey Williams and his relationship to Jeffrey Williams, and the fact that in this call where he's comfortable, he is not saying anything about little Jeff and him not speaking to little Jeff. He's saying, do you think, can you get Thug to throw me a fundraiser? I think that's particularly poignant when he is also wearing a Free Roscoe hat at the time that he's in the interview with Detectives Edwards and Gaither. And as the court will hear later on, we expect that Free Roscoe campaign was one that was begun by Mr. Williams to aid Jimmy Winfrey and his release after he had been jailed for shooting Lil Wayne's bus. So all of the conversation that takes place with the person named Erica and Mr. Murphy contradict what he conveyed to the court and to the jury. And there are specific portions of it that are simply inconsistent with what he testified about on the stand. The court would indulge me 1 second to make sure I haven't left off anything. And I have another case for the court, Henderson, if the court already does not have it, versus the state. It's 317 Georgia 66. It was decided August 21st, 2023. And the pin site for that is page 82, I believe. And that further illuminates the analysis regarding the other call that we spoke about. And of course, the court already has Kemp, Henderson cites Kemp, which was decided in 2018. And unless the court has further questions of the state, I will take my seat at this time.
do. Specifically, what about the statements on the July 15th call that Mr. Murphy makes? He's saying he's being charged with murder and the stuff in Thug's house.
That has to come out.
Are you going to exclude the stuff in Thug's house? Because remember, I've already ruled on that.
Absolutely, and my
references to that
apologies
would
for
have
not
to-
making that.
Would have to be
clear.
excluded. Okay, what about the issue of the charge of murder?
Two things about that. So Mr. Murphy was charged with attempted murder and gang activity. And what,
Bless you.
yes, bless you. And what I believe, what we noted and I believe asked various witnesses about was his concern about the gang charge as opposed to the attempted murder charge. The gang charge, he was false flagging is what he testified about to the jury. He said he was a false blood.
I got all that, but what does the charge of him saying I'm charged with murder have anything to do with this? With the call itself and the conspiratorial nature of it? Or not conspiratorial, even impeachment.
Right. Your Honor, just giving context to what he's discussing regarding when he talks about they got me in the car with those guys.
Well, that's relevant, I mean, for the jury's consideration, but no.
Right. And
what about the charge itself?
so obviously
How is that impeachment? Because you're not using this for conspiracy. You've already told me that. You said you're using this particular call for impeachment by contradiction of Mr. Murphy's testimony.
correct.
So how does them being charged with murder impeached, and how's he to be impeached on that? I think he was already acknowledged the fact that he was in custody
Right.
when he testified.
So, and as the court knows, he wasn't charged with murder. That part, I think the jury was able to hear in the court during his interview with Detective Gaither on July 15th, that he was not charged with murder, but with attempted murder. I believe that that's a matter that, as far as the accuracy of the charge, that the jury can easily discern and understand. And
But he pled to that. So, I mean, he pled to another charge in that particular case involving Mr. Dexter Montgomery, correct?
Right, he was never charged with murder in that case. He did plead to aggravated assault and other charges. Yes. And so what we're saying about him talking about the charges is that they simply give context to the remaining portions of the conversation that he has with Miss Erica. He is clearly, after saying what he's charged with, he then goes into lamenting what evidence that the state has or the police has against him on those charges. So I would just say that it's not that that particular statement contradicts anything he said or is inconsistent, but that it gives that kind of, it's a reciprocal and integrated utterance that gives context to the remaining portions of the conversation where he talks about how they got him in the car. And
I understand later in the call how that happens, but I don't believe that that statement should be in the charge of murder. I think that everything else is, other than the statement about stuff in Thug's house, everything else is pretty much would be or could be presented as impeachment by contradiction.
So is it, he does in the first 50 seconds when he's crying and saying he has been charged with attempted murder and gang charges, there are two instances, could you put that back up? There are two instances where that happens. And at 2 minutes and 25 seconds, he says,
I don't think what he's charged with has anything. You're missing the point. You want to impeach him by contradiction. There's nothing which he said that is contradictory in nature. And I'm gonna disagree with you respectfully about not everything's context. So take out those references to his arrest at this point. Everything else, other than the stuff with the items at Jeff's house, which you said you're going to take out already,
yes,
because that's part of the suppression. Everything else is relevant for those particular for that particular impeachment by contradiction as to what Mr. Murphy said. Okay?
we can definitely do that.
All right.
Judge, the only thing I wanted to make sure I was clear about is the reason I was bringing up that the first 50 seconds had that stuff we're taking out about the murder charge. Later down at 2:25, when he says, I never thought that this would happen to me. Murder, come on, bro, I gotta find some kind of way, bro. We gotta ask Thug to start a fundraiser or something. That portion right there was where I was also saying that it gave the context. It's different than the one where he's up there talking about, I'm charged with attempted murder, gang charges, and he's crying and saying telling her not to cry, he's sorry. Those are two separate places. So I just want to make sure.
You can still edit out. He says, at least in his phone call, about 3 times about this. You got to go ahead and ask Thug to do something for me. And I'm just paraphrasing in terms of fundraiser. I think he mentions that twice, and then there's another time assistance. So yes, it would go to if the jury believes it, for his contention that about the relationship between the two of them. But I would ask that you just, kind of cut it out at this point in time.
Okay, so we'll be taking out.
You can blip the word or whatever, but I think that the rest of it is contextual in terms of what is being asked of, or potentially asked of Mr. Williams.
I got it. I see what
Okay.
you're saying. Yes, Your Honor, I see exactly
All right.
what you're saying, so we can do that. For the court,
Okay.
Judge. And while I'm questioning the witness, my team will be making certain that we comply with everything the court has directed.
All right. All right, Mr. Steele, Mr. Matthews, and Mr. Short, over objection preliminarily, subject to a foundation being laid, and your objections that I'll note for the record and make it continuing. I'm going to provisionally say that these two phone calls on the July 15th of 2015 and August the 1st of 2015 will be admitted, subject to the redactions that the court is in agreement in terms of now the August 15th, 2015, the home invasion references shall be deleted, as well as the probation, jail, and prison time. And as it pertains to the July the 15th of 2015 call between Mr. Murphy and Erica, the charge of murder, those references will be taken out, as well as any references regarding the stuff in Doug's house, referencing the search that the court has already ruled upon. All right. Okay. Mr. Steele? Anything else in regards to these two phone calls?
I think it may be obvious, a continuing objection.
I said I would give you that. Yes, sir.
And then I still believe, I don't know if the court ruled on it, the state is doing, they don't have the right witness. They don't have any witness on the stand who's a speaker in either of those recordings, and they did not ask Mr. Murphy or Mr. Stevens about those. So my position is, I understand they're using the word impeachment by contradiction.
That's only as to the 15 July 2015 call, which would be to impeach Mr. Murphy's statements on the stand. The phone call on 1 August of 2015 would be allegedly co-conspirator statements.
And I just want to voice the opinion that anything that is inconsistent, as the state said, or contradictory should have been confronted to Mr. Murphy. So I just want that objection to be included. I don't want to waive that objection.
All right.
And Your Honor, just to piggyback, I do believe that there are authentication issues that are going to come up with this. And I guess instead of raising it in front of the jury, I'll just raise it now. I understand that perhaps voices could be identified, but still there's no reference of date or time that these calls were made.
Well, that's 1 August of 2015 and 15 July of 2015.
Right, but how does I understand that Miss Love told us that, but Miss Love is not a witness in this case. And to my understanding, I can be corrected if I'm wrong, but Investigator Gaither did not pull these calls. Maybe I'm wrong. And
I think she testified yesterday. She did. Maybe I'm mistaken. State, is that what did she say about these jail calls? Yeah. Yeah, I thought that there was some testimony about her pulling these calls.
The date that she pulled them? I mean, the date of the calls? Because I think that's going to be an issue.
That's the foundation. I said subject to foundation, sir. Okay, so I got to hear it in order for me to rule upon it, okay? All right. Okay, folks, let's take 5 minutes or so. We can take comfort. Did you have something else you want to say?
For the abundance of caution, yes, thank you. I am not agreeing with Mr. Short's statement that Ms. Love is not a witness in the case. I don't want anyone later to say that I somehow waived that issue, that she is an
All right, sir. Okay, we're in recess. Give me 5 minutes, then we'll call for our jurors and our witness, okay? All right.
Good morning, ladies and gentlemen. Good morning, good morning, good morning, good morning. You got some visuals here. Ladies and gentlemen. Good morning. Okay, we're on a comfort break. Let's go into the courtroom. Not the courtroom, but let's go into New York City right now. Let's see what's happening in New York right now with former President Trump. Okay. We're going to take you guys into New York. Stand by. We're going to go into New York City because that is a very important trial that is going on right now. And I want to see what is currently happening there. So, and I want you guys to see it as well. Let's go. Okay. Okay, this is the scene outside the courtroom. Okay. Let's see if we have former President Trump come out. Okay, let's see here. But you can see two of the New York State court officers, the two sergeants apparently. Somebody from the DA's team as well. They didn't stop him, so he's obviously a recognizable figure in the courthouse in New York State. New York City. Okay. We'll bring you back in the courtroom when Judge Glanville takes the bench and the next witness gets on the stand. Okay, let's see what we gonna. Let's go over here to Instagram real quick. We know that you guys are watching from Instagram as well, so maybe I missed a comment or two. Okay, we're going to take you guys back to Atlanta. Hold on. Okay, what do we have here happening? Hold on. I think we're gonna get a shot at the former president, maybe. Yes, there we go. There go Donald Trump, ladies and gentlemen. There you go. There you go. Okay. He's walking up to the cameras. Okay. Okay, hold on. We need sound, guys. We need sound over here. We need sound. Oh my goodness. We need sound. Okay, guys, we need sound coming from the courthouse. Come on, we need the president's sound. The former President Trump, we need to get the sound. Stand by. We're gonna bring it. We're gonna bring sound up.
This is an assault on our country.
There we go.
It's a country that's failing. It's a country that's run by an incompetent man who's very much involved in this case. This is really an attack on a political opponent. That's all it is. So I'm very honored to be here. Thank you very much.
How will you be campaigning over the next several weeks?
And for those who are saying he's not the president, but each president, President Carter, President Ford, President Kennedy, President Bush, they all refer to with the prefix as president. Active president is Biden, but they all still holds the name of president, former president. I mean, it depends on. Listen. There are people that hold professional titles, doctors, doctors, esquires, judges. I still refer to certain judges who are retired as Judge this because it shows a level of respect. To even hold the office. We're going back into YSL. Stand by, ladies and gentlemen. Stand by. I don't want to talk your ears off. Stand by. So we're gonna go back into YSL. Get him back over there. He's not the president. Don't say that. Blasphemy. Calm down. Don't get your panties in a bunch. Don't get your panties in a bunch. That's right, Vanderveer. That's right. You know what it is. Leak you, my good buddy. Leak you in the building.
All right, thank you, Deputy Ham. All right, ladies and gentlemen, please be seated. All jurors present, sir? Yes, sir. Okay, all right.
Thugga.
You sure? Yes, sir. All right. All right, ladies and gentlemen, please be seated. All right. Ladies and gentlemen of the jury, good morning. Good morning. All right. Without further delay, we're going to continue with the examination of our current witness. Investigator Gaither, you're still under oath, madam.
Yes, sir.
Okay. And remember, speaking in the microphone, and Ms. Love, you can, your colleagues as well.
Okay, continuation with Investigator Gaither, Detective Gaither. We cannot show her face because she's undercover.
Thank you, Judge.
It wasn't you, were you pointing to Ms. Renard? That's terrible.
The lawyers are snitching on each other.
15, something like that. Maybe I need to confiscate it because I got like a real old phone.
The lawyers are snitching on each other. What the heck is
Detective
going
Gaither,
on?
I'm going to go back
What's
to
it?
the July 15th, 2015 interview that you had with Mr. Murphy while Detective Edwards was in the room. Do you recall a time where you mentioned to Mr. Murphy something about, I'm going to let you go and sober up or something like that?
Yes.
Would you explain to the jury if you had detected an odor of alcohol on him?
No.
Okay. Why then was it that you made the comment about sobering up?
Believe it, earlier in the interview, he stated he gets high all the time and he doesn't remember stuff. All the days kind of run together. But then he contradicted himself by saying, you know, just before he was arrested, he had just woke up, jumped out of the bed, threw on some clothes, and went to the location where he was ultimately arrested. So I didn't believe he was high. He appeared coherent. I just stated that to him because he said, you know, he does drugs. So I wanted him to have the best opportunity to give the facts of the case as best as he could remember in a sober manner. So that's why he asked for my phone number and I gave it to him.
Okay.
And he reached out later.
And he did what?
He reached out to me later. Well, his attorney did.
Okay. Now, would you explain to the jury whether or not you had access to jail calls made by inmates of the Fulton County Jail during that time, July 15th of 2015?
I did.
Would you explain to the jury how you'd go about retrieving those jail calls?
You receive a login into Securus, which is the system that the jail uses to allow inmates to make phone calls. We receive authorization from the sheriff to get access to the Securus system. So I logged in and input the information that I wanted.
Did each inmate have a PIN number assigned to them once they were fully booked into the jail?
Yes.
Prior to being fully booked into the jail, did the inmates have access to a phone in the booking area?
I'm overrule the objection, sir.
Yes.
All right. Would the phones in the booking area of the jail carry a name attached to them, or would they simply be labeled booking?
They would be labeled booking.
Now, without the actual PIN number of a certain inmate, would you explain to the jury how you'd go about looking for calls made by that inmate?
If I was able to interview the person prior to them being booked into the jail, I would try to get a telephone number for them or a family member, someone close that I believe they would, you know, be the first one to call once they go to jail. So that would be a tool that I would use to basically do like a reverse search. Instead of having the inmate's phone number or their booking number, you can simply input in a number that you're familiar with that the inmate has, and it will give you all calls made to that phone number.
In the interview with Walter Murphy on July 15th of
She reviewing
2015,
techniques. Interesting.
did we hear Walter Murphy offer to you the phone number of his then pregnant girlfriend?
Yes.
And did you use that number to do anything as it related to Mr. Murphy's jail calls?
Yes, I inputted that phone number into the security system, and it showed me one of his first phone calls, which was a booking call before he was assigned his PIN number, made to that number.
And during that call, could you hear Mr. Murphy's voice?
Yes,
Did you recognize that voice as the person you had interviewed on the 15th?
yes.
And did he address the person he was speaking to by name?
I don't recall if it was by name.
Did he give contextual details about the person he was speaking to that were consistent with the girlfriend he described in the interview?
Yes, and also prior to the call being connected, you have to state your name before the person can either accept or decline the call. And I believe he said his name was DK on the call.
Was that call made shortly after Mr. Murphy left the interview room with you and Detective Edwards?
Yes, it was the same day. I'm not sure of how long, but it was definitely the same evening.
As you listened to the call, were you able to observe the manner with which Mr. Murphy spoke, i.e., whether his voice was slurred, whether his speech seemed impaired, anything of that nature?
Yes.
And would you explain to the jury whether Mr. Murphy during that call, based on your observations, suffered from any impairment that affected his ability to understand or hear clearly?
Objection, speculation.
Overruled, sir.
You may answer.
No, he didn't appear to be effective in any way.
And during that call, did he vocalize to the called party the experiences that he had just had with you and Detective Edwards? In other words, did he tell Eric about what had just happened?
He did.
Did he seem to have any, were you able to observe any particular difficulty that he had remembering what had just taken place?
No, he seemed to be giving her details of what we spoke about, details about their prior days leading up to that. He seemed coherent and understanding of what was going on.
Okay. Later on in August of 2015, did you have an opportunity to listen to a jail recording between Trontavia Stevens and Rodney Allison?
I did.
How were you able to identify? Let's start with Trontavia Stevens. How did you know it was Trontavia Stevens that you were listening to?
Well, first he stated his name on the call. So once you place a call, it's a pre-recording that you have to do to state your name. And he said it was Slug, which is one of his nicknames. And also I was familiar just with his voice from previous interactions and other jail calls.
And what about Mr. Allison? Had you had an opportunity to hear Mr. Allison's voice before then as well?
I had heard Mr. Allison's voice really from the start of our investigations. As we would arrest people, several individuals reached out to him via jail calls once they were arrested. So I was familiar with his voice based on those previous calls.
Were the details that were discussed in the call between Mr. Stevens and Mr. Allison consistent with details that you were already aware of prior to making that call or listening to that call?
Yes.
And did you preserve both the call from Mr. Murphy to Erica and the call from Mr. Stevens to Rodney Allison?
I did.
Okay. We'll get back to those. When you spoke about the gang unit having access to each other and each investigator having access to the other's intelligence, would you explain to the jury if on your individual cases, the investigators utilized or had access to the same details, sources, facts as they were evaluating whether or not to make a classification of a person as a gang member?
Objection.
Basis. I'll overrule the objection.
You may answer, and if my question was unclear, let me know.
I think I understand what you're asking. Well, every case is really case by case. Facts and circumstances of every gang investigation or even just crime or incident are different. So there's not a cookie cutter set of rules that you can use. Also, every detective's skill level or knowledge of the tools that they have and how to use them, they use them differently. So in my opinion, everything is case by case. You can't just use the same pattern to prosecute or charge every case, but we do follow by same Georgia law regarding identifying and charging gang cases. But as far as the investigations, everything is case by case and skill set based on that particular investigator.
And that's as to gang members. Would you tell the jury whether the same thing is true?
I sustain the objection.
I'm asking you now about the gangs themselves.
Mm-hmm.
Is the same thing true when an investigator is looking at a group of people to determine whether it constitutes a gang for your purposes? Does each investigator have access to the exact same information about the groups of people that they investigate on a daily basis?
I'm objecting to confusing the question.
I'm gonna sustain it for other reasons, Mr. Steele. Move on.
Thank you. When you and Detective Dennis worked together, did you always travel together?
Objection relevant.
I stand the question.
When you and Detective Dennis worked together, did you always evaluate your cases together?
Objection asked and answered.
I stand the question.
When an investigator with the Atlanta Police Department evaluated whether or not to classify a group as a gang, did each investigator rely on the same sources to make that determination? Not protocols, but sources.
Objection.
She was a member of that unit.
Hold on. I'm gonna sustain it for other reasons. It's been asked and answered a bunch of times, so let's move on.
Okay.
Okay.
Would you tell the jury whether or not you were familiar with 3 or more people in the organization YSL who had committed crime? I heard an objection, so I'm gonna stop.
Basis.
Objection. Not aid the jury. I object this goes beyond 702 analysis.
Remember, she's testifying as a fact witness now. We've gone past that, so.
Well, then that would be a different objection. It would be an opinion without the lay witness, without me. Still
I'm
doesn't.
sustaining the objection.
During your time with the gang unit, did you have the occasion to personally observe and interact with at least three members of the group called Young Slime Life?
That would be asked and answered.
Your Honor, I have to lay a foundation for the question I'm gonna ask next.
We approach.
Sure. least sit down.
Every time. Your Honor, with the court's permission, I will approach Investigator Gaither with what we have labeled State's Exhibit 106, Bravo Bravo. It is a digital file that has been provided to the defense on a thumb drive. Earlier this weekend was provided in discovery in 2022. But I'd like them to see what I'm presenting to the witness, if either of them would like to look.
All right, madam. All right, you may approach.
Thank you. Investigator Gaither, I'm showing you what has been labeled as State's Exhibit 106 Bravo Bravo. And the thumb drive I identified earlier. Do you recognize the thumb drive, first of all?
Yes,
How do you recognize it?
it's the one I saw earlier this week in initial.
Just speak
It's
up.
the one I'm sorry, it's the one I saw earlier this week and put my initials on.
And is State's Exhibit 106 Bravo Bravo, labeled Murphy Booking Call, a digital file that you also reviewed earlier this week?
Yes,
And is that an accurate recording of the jail call that you were able to retrieve after Walter Murphy was taken to the Fulton County Jail?
yes,
Your Honor, the state tender State's Exhibit 106 Bravo Bravo, subject to the court's earlier ruling.
Any further objection? All right, subject to the court's earlier rulings, States 106 Bravo Bravo is admitted and may be published as you see fit.
Thank you, Your Honor. Ms. Hilton is going to do my honors.
This is a free call from an inmate at Fulton County Jail. This call is subject to recording and monitoring, and your location information may be collected and used by corrections and law enforcement personnel. To accept this free call, press 1. To refuse this free call, press 2. Thank you for using Securus. You may start the conversation now.
Hello. Erica. How you doing today? Not good. What's going on? What you not telling me? What's going on? I never knew when I woke up this morning that I would be charged with murder.
we're gonna pause at 44 seconds and move to 1 minute.
Is the voice that we just heard the voice of Walter Murphy?
Yes,
Okay,
the male voice, yes.
thank you. Your Honor, can we position the speakers a little bit closer because we're being told that the jury can't hear the audio coming in over the Zoom?
Sure, that's fine.
Speak up, I can hear you.
It's not the sound. You don't know what he's saying. I can hear her, not him.
Okay, understood, Judge. We'll have to work through that. Thank you.
The car was supposed to be on his way up there.
For what, a jail?
Yeah, to see what's going on. Like, bro, like, I'm gonna have my baby, bro. Like,
Don't do that, please. I'm sorry, but don't make me listen here, bro.
you said what?
Saying don't make me break down crying here, bro.
I'm not trying to, but like, this why I asked you last night, like, bro, like,
Stay with you. I should just stay with you. My God. I haven't touched you or nothing, and I didn't love me up. Like, we haven't had sex or nothing. And they told us shit happened 3-4 months ago, bro.
exactly, and then you just went to court. That's what I don't understand. Why didn't they lock you up then?
Bro, they want me to tell, bro, like I was with the folk, but, bro, I'm not, like, bro, they already got me on camera and shit, bro, like, I'm not gonna sugarcoat shit. I'm gonna keep it 100. I'm gonna tell you everything. So you, like, bro.
Hmm?
I never thought this shit would happen.
We're gonna stop at 227 and then to 231.
I gotta find some kind of way, like, I don't know, like, bro, we gotta ask Doug to start a fundraiser or, like, something, bro. I gotta get me some money. I gotta get out of here, bro.
That was because he was like, this gonna be my money. I don't care, bro. Whatever you was finna get, bro, you just not gonna be able to get, bro. Like,
Jacoby?
yeah.
Man, bro, that nigga James, they wanna fire him, but don't tell me he said no shit. Like they gonna be more money.
Nah, he was just saying, like, you not gonna get a chance. He's like, what the fuck? Like, what do BK got to do? What is it? I don't know. I don't know what to tell him. I said, I don't know, Jacob. I don't know what's going on. Like, I went back through my text message to see, like, what we've been talking about around that time. And that shit, all I think about is, all I see is Pokey. So I don't know what you got going on because you ain't told me nothing. Like,
I'll talk to you when you come and visit me. But I can't talk to you over the phone like that. And I'll write you. But, like, seriously, Erica, like, for real, bro? What the fuck did I do to God? Or whoever, bro? Come on, man. Like, I should just listen to Bird, man. But the man sat and told me, bro, stay with me, nephew. I ain't nothing out there for you but trouble, bro. This man just sat there and told me, bro. I ain't nothing out there for you but trouble, nephew. Stay down here with me. And I ain't listening, bro. Now I'm about to have my son, and I'm not even gonna see him get born. Like, come on, bro. This shit hurt me so bad. Like, bro, I've been throwing up. I haven't ate all day. I got the bubble gum and shit. But this shit is not right. It's like, I just feel like this whole time was for nothing. Like I just all my child ever, I loved you, and then I just throw it all away for no reason, and I'm sorry. And it's like God knew this was gonna happen to me because he just so like you see how you pulled up. You see how that happened?
mm-hmm.
And we talked, and then I'm like, nah, we ain't going down there. Then I'm like, man, Sanjay made me change my mind and go get them.
You see what I'm saying? Yeah. Like, I don't even know what to say. Like, who with you? Where you at? I'm outside of my house. I'm just sitting in the car, bro. You need to. I don't trust you right now to be by yourself, Erica. Like, bro, I know how you is, bro. You need to I need to talk to somebody who I know can watch over you and make sure that you're straight, bro. I don't want you to try to do nothing to yourself or nothing. I'm still here for you and everything. I don't need you to try to do nothing to my baby or none of that, bro. I need to talk to Jessica or this or somebody who can come over there and stay with you and give me their word that they're going to watch over you and him, bro. Because it's okay. Well, what am I going to do? Like, oh, I don't know. Don't make me say something that I'm going to regret. I don't know what you're going to do, Eric. I don't know. I can't even eat. It's like, me either, bro. But I've been told you this last night, like, bro, like, that's what I was trying to tell you last night. Like, we got to start a fundraiser or something. We got to get me some more money so I can get a better lawyer, bro. Because they got me in the car with the people on camera, but they do not have the shooting on camera. You see what I'm saying? Yeah. They got me in the car with the people on camera. They showed it to me on camera. But they do not have the actual shooting on camera, and the person is not dead. He's just just brain dead. You see what I'm saying? Mm-hmm. She's saying he's going to have a metal plate put in his head and shit. That was what she was telling me. And they wanted me to tell. But, bro, you know what'll happen if I do that, right? Mm-hmm. Right? Yeah. Okay. I just wanted to hear you say that. But so, like, I don't know, Rick. I don't know. I've thought about everything. And I tried everything. And I just need some help. I don't know. Oh, my God. I thought about it. And then that shit just fucked up because I don't have nothing. Like, I don't have no type of nothing this time. Like, what do you mean? Like, I don't have no type of money. I don't have nothing, bro. Like, okay. You got another phone right now? Mm-mm. You know I don't. I wish you just would have came up my house, came home. I told you, like, boy, it's not like that. I told you why everything went the way it went the other night because you being disrespectful. Yeah. Like, and I told you that. I'm sorry, but my mom, bro, I'm sorry, bro. I'm tell you the truth, bro. I listen to Dolly. I listen to my mama really, and then Dolly was like, bro, you know how girls is, because I've been through that, bro. I kick nigga out quick, you see what I'm saying? She wasn't saying like you just intentionally doing it, but she was saying like the same thing my mom was saying. My mom was saying like, bro, Erica just trying to get the apartment to kick you out. I'm like, and I was just listening to them when I shouldn't have, and that was wrong, but we can't fault nobody right now but me. You're right, but I'm saying, me and you is better than what everybody was saying. Like, you knew what you had done. You just be trying to make it seem like it be me tripping, bro. Like, you knew, like, why I felt the way I felt, and you knew what I was doing. Didn't nobody say, no, you can't come here or nothing like that. So I don't understand why you be trying to make it seem like the other people that it be there. And then you took all your clothes and stuff like that. Like, that shit really hurt my fucking feelings. Like, that shit really hurt. Like, okay, if you don't want to go through this with me, bro. It's not that, and then like you ain't even called to see that I make it home okay. This last night, I was just like, damn. When you get home, I wanted to see what you gonna call.
All this shit, but God knew that this was gonna happen to me, bro. I swear to God, you were trying to see what I gonna call, and I was trying to see what you gonna call, bro. Oh God. I sat right there and waited, bro. Dollar was asleep. And I was watching the movie and Dollar was asleep, bro. And I thought about it. I said, I should grab her phone. And I said, no, Eric ain't call me, so why should I call her? Bro, that shit so fucked up. And bro, even with Thug just getting locked up, like Thug getting locked up, I'm like, damn. The only person I can think of.
Excuse me, 11:05.
Cause you all like that, like, bro, to be honest, bro, ain't nobody finna be here for me, bro. I already know how this shit finna go, like. Either we gonna try to talk to Thug and I'm just gonna ask him straight up and down, like, start me a fundraiser, you know what I'm saying? Like, to really go on his page and start me a fundraiser, you know what I'm saying? And ask Dora or somebody like that, they'll really be over it, or tourist, you know what I'm saying? Cause that's the only way I'm gonna get out.
So you really think, like, you don't think you can get out no time soon?
I don't want to go through this again, Erica, because I said I wasn't getting out last time when I got out, and I honestly thought I wasn't getting out. Last time, and I did, so I can't say. Like, I can't say.
I just hate, like,
No. I know. It's motherfucker. I'm going up into the 7th floor. My back fucked up. My arm go out. Every time I lift up. It is just bad, bro. It is bad.
you gotta be strong, though. Like,
Your Honor, for our purposes, we are going to now stop that portion of the video at 12:38. Detective Gaither, was there anything that you wanted Walter Murphy to tell other than what the jury has already heard from the July 15, 2015 interview?
Wanted him to tell as in regards to our investigation.
Yes, in regards to the April shooting of Dexter Montgomery.
I would have liked for him to tell the truth about the other 2 occupants that were in the vehicle with him when the shooting occurred.
And at any time, either on jail calls or in interviews or conversations with you outside of the interview room, did Walter Murphy ever indicate that the people in the blue vehicle threatened him with harm?
Asked and answered.
I stand the objection.
Are we ready in there? Your Honor, at this time, if I may approach the witness with State's Exhibit 107, Bravo, Bravo, which we have provided to the defense, but are willing to show so that they can see what I'm approaching the witness with.
All right.
Investigator Gaither, I am showing you what is a digital file on the thumb drive that you identified earlier. Labeled State's Exhibit 107, Bravo, Bravo. Stevens to Allison. Have you had an opportunity to listen to that audio file?
I have.
Is that a booking call made by Trontavious Stevens to Rodney Allison?
I believe that.
What? I'm sorry, a jail call. Thank you, Mr. Steele. Is that a jail call? Thank you both. That you identified that came from Trontavious Stevens to Rodney Allison?
Yes. Yes.
And would you tell the jury how you were able to recognize the caller who was inside the jail?
He stated his nickname Slug. Also, when researching the actual jail calls, it appeared under his full name, Trontavious Stevens. And also I recognized his voice from previous.
That part will be yourself.
Oh, will, sir.
And I also recognized his voice from previous interactions.
And was this a call that you were able to pull from around August 2nd of 2015?
Yes.
What about the called party, Mr. Allison? How did you recognize who that was?
I reckon.
That's not it.
Okay.
Sir.
You may go ahead.
I recognize his voice from a lot of jail calls. There were several people in Fulton County Jail that were making phone calls to him that we were monitoring during the course of our investigation. And I just recognize his voice, people saying his name is hot. So when Mr. Stevens called him, I recognized his voice and the phone number that he was dialing out to.
And so you've actually gone into another area I was going to ask you about. Are the phone numbers that the persons inside the jail dial, are they visible to you as you are looking at Securus and listening to the calls?
Yes, it displays the number being called to.
And as you listened, did you recognize elements of the conversation?
Yes.
At the time that you heard this call, were you familiar with anyone associated with YSL who was called or who went by the name Little D?
Yes.
Was there one or more than one Little D at this time that was associated with YSL?
There were two associated with YSL, but I was familiar with both gentlemen.
And what were the names of both those gentlemen that were called Little D?
We had Little D, Quindarius Zachary, and also Little D is known as Demikion Garlington, common speller.
Was there any distinction between where the two lived, or did Demikion and Quindarius live in the same part of whatever town they lived in?
No, they were from two different areas of Atlanta.
What part of Atlanta was Quindarius Zachary from?
He was from Cleveland Avenue.
And what part of Atlanta was Demikion Garlington from?
I believe he was born in Old Fourth Ward area, but he spent most of his time in Mechanicsville.
And did Demikion Garlington associate with members of both YSL and Inglewood family?
He did.
Did Quindarius Zachary associate with both or only one?
Just one.
Which one?
YSL.
All right. Is the recording that you've identified as State's Exhibit 107 Bravo Bravo a fair and accurate recording of the call that you listened to, that you pulled from August the 2nd of 2015?
Yes.
Your Honor, at this time, the state tenders State's Exhibit 107 Bravo Bravo as evidence, subject to the court's prior ruling.
Any further objection other than the court's earlier rulings?
Nothing further.
Okay, all right. States 107 Bravo Bravo is admitted subject to the early rulings of the court. It may be published as you see fit.
Thank you, Judge.
An inmate at Fulton County Jail. This call is subject to recording and monitoring, and your location information may be collected and used by corrections and law enforcement personnel. To accept this free call, press 1. To refuse this free call, press. Thank you for using Securus. You may start the conversation now.
What's up, my nigga? What's up, who it is? It's Lord, man. Oh, what's happening, baby? What you doing? Shit. Yeah, cool. Yeah. You ain't got no shooting these damn dice. Huh? I'm bullshitting on these dice. Shooting dice? Kill it. Yeah. I never seen you shoot dice. No way. Why you answer the phone? You gambling, man. Man, I don't care. Well, how is what's going on? You alright? Yeah, how Jeremiah doing? Man, he got down, he got to go through therapy. Really, he can't walk? Nah, he can't walk or talk right now. Dang. They fucked that boy up. Dang. That man fucked up for real. Hey, you watch my video? Yeah, I watched it. You better go back to court though in a minute. On the 17th? Yep. That's what she said. Hell yeah. I know you can't wait, boy. Hey, what the? I ain't seen my shit either though. I know you can't goddamn wait to get in that motherfucker so you can get the hell up out that motherfucker. He ain't talking nothing. Yeah, I talked to him yesterday. What you talking about? He get out and he'll be home and he got like 20-something more days. Oh yeah. He did tell me that 2-for-1 shit. He told me not to tell nobody. Yeah, he on the way. His ass on the way. Yeah, his ass need to get out. Damn sure do. So I can blow his phone up like he doing mine. Nah, you'll be out, man. Man, they tripping, man. They tripping. The pub finish all that. It look like all that shit mine, man. No, hell no. They can't do no shit like that. Tell him what he said. Man, they told you.
Your Honor, we are stopping at 2 minutes and 57 seconds, and we'll pick back up at 4 minutes and 5 seconds.
And then, man, what the hell, man, that boy tripping, man. Who? D? What he do? You know Mook took him locked up. Yeah, I was at court with him the other day when I had no court with him. That's dope. Yeah, his ass locked up. Oh, y'all just huh? Yeah, I said, they done locked up all of them, man. Ain't number 2 of them locked up. No, they wouldn't lock somebody else. They were telling me they locked somebody else up to death or some old shit. Who? I don't know who the hell they were talking about. I don't know them young niggas right there who they talking about. But you know them. You'll probably know them. Hell yeah, man. Shit been going on, but the same old shit. But I'm to my home, you need to talk to him. Who? Lil D. What you doing? My name. What? Yeah, you know who I'm talking about. Yeah. Tell that man, tell him if you could reach out to him, tell that man, chill, man, you tripping. Man, I sent the message to his I told, I was like, look, man, y'all talk that nigga and tell his ass chill, man. That's all he got to do is chill, man. He tripping.
That man, I'm tripping for real. That shit crazy.
What the boy doing?
What one?
Rapper boy.
Oh, man, I just was talking to his ass, too. I just talked to his ass. He ain't talking about shit. He ain't talking about nothing, man. Say he finna go out of town or some old shit.
You ain't trying to give me no lawyer, man?
Man, hell no. Hell no. Well, shit, man, I don't even know why you even think he gonna goddamn. Man, that man ain't. Well, if he is, he doing that secret. I don't know. So don't let me say. He ain't tell me nothing about getting down. He ain't say shit about that. Now, I ain't gonna lie. Now them folk went so stupid at the club Thursday, so it didn't make no sense, man. Nigga hit BB so goddamn hard. That nigga, yeah. Man, they damn near beat that boy damn near the dildo.
Why they doing like
that? And then he hit BB. And then when the ambulance folks came and got him, he hit but the ambulance, man. The ambulance lady and bust her nose.
Who did that?
That young nigga. Hey, what that young nigga name though? Who did that? He be with Kale. Get what Kale dumb ass finna do.
What?
Man, that man finna try to bug BB. That man finna try. Man, it beat the police out there. He told me I'm gonna bust me and I'm gonna run through the pub. I said, man, them folks gonna flatline your ass. You do some dumb shit like that.
Well, let it shoot there and get flatlined.
That one finna goddamn show him. I started to. He dumb ass. I started to too, boy. Cause that was just some dumb shit what he was doing.
Why they going home for?
Nah, see, but the nigga was in the club, dead ass drunk. So, you know, Holmes just in the club just swinging on anybody, boy.
Ooh.
The nigga he with, I don't know that little nigga he be with. They be with. Man, they say he got 36 charges. He down there somewhere. Then he was kill. I'm finna pop B ass, boy. I'm finna hit the parking lot. I said, man, they fit the police right here, man. Cause after the fighting shit started, you know, so many goddamn police came to it, wasn't funny, boy. And then he was talking about doing that. I said, man, them folk, he said, look, man, what's gonna happen to you? Them folk gonna flatline you right here. I said, you pull that thing, man. He told me, no, fuck that. I said, well, go ahead then. I'm going to do what you talking about you finna do. Stupid ass. And he was like, I'm gonna just wait, I'm gonna get him. Man, you ain't finna do shit. But one thing I ain't been asking about you though.
Oh.
And I know you don't fuck with him, period, but on everything I love, that nigga came at me. Matter of fact, he just at me yesterday. He said, if Charlotte needs something, let me know, man.
Who?
Bentley.
Oh, fuck that.
I'm just telling you what he said. He was dead ass for real about it. Cause you know he not the hell he ain't. Cause you know he got he him right now. He him. He the one. He him right now. Just listen what I'm telling you. I don't know who the fuck, but he him right now.
What that mean? You haven't been waiting.
Yeah.
But
yeah, I'm telling you straight the fuck up. Yeah.
Fuck that nigga. Can't know he was dead ass wrong for what he did, man. I'm sending to my house, bitch ass nigga.
Yeah, you dead ass right.
From that nigga, fuck that bitch ass nigga.
That right.
Ain't so much thank
you. You dead ass right. But get what?
Yo ass, I left him alone, bro.
I know it. I already know it. These niggas been going crazy here. But they been locking up everybody, man. I'm talking about these folk, these folk, I'm talking about they just snatching niggas up, man. Putting all type of charges on niggas. I'm talking about dead for real. So get what I said. Get what I said. God moved you out the way for a reason.
Yeah, that happens too.
He moved you out the way because what they getting these niggas for, man, these niggas, only way they getting out of it, they got to tell something.
Yeah.
Yeah. So, they been goddamn, what's the name they got out yet?
Who that?
Moot too?
Man,
No.
that nigga had 18 stars. I went down there.
I know it, but they ain't let little what the name not neither though.
Man, he ain't gonna get no bun neither. He got a whole bunch of eggs. Yeah, I had one.
I know it, but still he supposed to be able to get a bond.
Please, man, you tripping. I had one ad, they wouldn't give me no bond for 3 months. He was already.
No.
Yes, I did when I pulled twist out on the police, boy.
For real?
Your Honor, we're stopping at 11:58 and we pick back up at 12:08.
Ain't that bad though. Them ain't no really no hell of a bad charge.
That one on the police though, man.
Yeah, that's why you ain't getting out for 3 motherfucking months. That's why you ain't getting out for 3 motherfucking months. Hey, stupid as motherfucker. Damn, man. That nigga, but you know that boy, he finna be out and you finna be out. Man, these folk locking up everybody. Everybody. They ain't sparing nobody. Hey, that nigga, they went looking for Yayo, right?
Yeah.
That's what Yayo did. That's what Yayo said. That nigga Yayo said, man, Boo about to straighten this shit out, cause boy, I ain't going down like that.
Nigga, go sit down. Nigga, fuck.
Hey, no, he said he ain't going out like that. He said, hell no. He said, I can't go out like that.
Man, I don't be throwing no nigga up on the butt. I ain't asking about no nigga. They come out your ass on. See what they come out by your stupid ass back home.
Yeah, you right. You right.
Yeah, this shit ain't got nothing to do with me. I'm out here saying, ain't got nothing to do with me now, charge, now time.
Now, not damn sure ain't for real. Hey, I can't lie, but deal went on you right here.
Now, one-on-one.
No, I'm talking about, none of this shit, whatever I'm saying, this shit went on you. You just came home, man.
Yeah.
You stayed home, how long you stayed home? About 2 weeks.
Yeah.
Damn. But you on the way back, man. Soon as you get your buzz, you ain't got to ask the nigga for a motherfucker dime. You ain't got to ask the nigga for nothing. Motherfucker. When I was telling that boy, he ain't talking about shit.
You have 1 minute left.
The rapper dude ain't talking about nothing, man.
That boy name ain't what they call him. That boy name Rapper Boy.
That's what I just said. That rapper boy, he ain't talking about shit. And I hate that shit every time you get fucked up. That nigga can't do shit for you. I hate that shit, man. That's some sucker shit, though.
That's some real sucker shit.
Yeah, damn right it is.
Hey, look,
shit.
I talked to my girl for me. Look, right? They just started this shit down here with, they be sending the iPad down here and shit. I need one. She tripping. Keep on talking about these other hoes and shit. Man, I ain't talking about that. I need one.
You want me to get you one?
Nah, you know, she got the credit card. You got to do it with the credit card, man.
What's up? You tell her call my phone.
No, you call her, man. Don't tell her you talk. Well, you got to tell her you talk to me. Like, look, man, get that man that iPad and shit and get that, man?
I'm finna get on that right
Thank
now.
you for using
I love you.
Cirrus. Goodbye.
Love you, man.
Investigator Gaither, are you familiar with any other Kel besides Kelvin Watts?
Yes.
And as it related to your investigation and monitoring this particular jail call, based on your knowledge and investigation of individuals in YSL and Inglewood family, the Kel that is being referred to here, is that Kelvin Watts?
No.
Cause for statement, objection, under the cause for statement. Also beyond the information you've ever been provided.
I'm gonna overrule both objections.
What Kelvin Watts are you familiar with through your what Kel are you familiar with through your investigations was associated with Young Slimelight?
I believe his first name was Markel, but his nickname was Hellkel.
The nard that you heard as you listened to this jail call, based on your knowledge and your investigation into this case and this call, are you able to determine what nard is being referred to?
Objection, Your Honor, cause for speculation.
I'm gonna wait and see what the answer is. Overrule at this point in time.
Yes.
How are you able to determine what nard is being referred to?
I'll overrule the objection, Mr. Matthews.
Just based on the investigation and knowing that Mr. McMullen at this time was currently in jail and also a suspect in the shooting from Browns Mill Road, I was aware that his nickname was Nard, first name Demise McMullen. First and last name Demise McMullen.
Thank you. And is that someone you had also identified as being a member of YSL?
Yes.
Were you familiar with a person named Yayo at the time that you heard this call?
No.
Okay. Were you familiar with the person named Yak at the time you heard this call?
Yes.
And how are you familiar with the person named Yak?
Through a prior investigation.
Okay. And what is the given name of the person you were familiar with named Yak?
Diamante Kendrick.
And is he seated in this courtroom? I saw you nod your head.
Yes.
Would you describe where he is seated and an article of clothing that he is wearing for the record?
This first defense table with the white, off-white, maroon and black striped shirt.
Is he seated next to the young woman in light blue?
Yes.
Your Honor, would the record reflect that she is identified Diamante Kendrick as the person she is referring to as Jack?
It will.
Thank you. Investigator Gaither, at the time that you were in January of 2015, did you, along with your partner, did you all begin to look through social media pages that were open to the public of persons you believe were involved with YSL?
I stand the objection.
Did you have an opportunity to look through Demekion Garlington's social media pages?
I have several times.
Okay. And in looking through those social media pages, did you come across a video of Jeffrey Williams talking into the camera?
Yes.
Okay. Your Honor, with the court's permission, I'm going to approach, but not before showing to counsel for the defendant what I have labeled as State's Exhibit 112 Bravo Bravo.
Madam, before you do that, can I get you and a member of the defense team to come up, please?
Yes, Judge.
Yeah, don't need. Ladies and gentlemen, it being the noontime hour, we'll go ahead and recess for lunch. So if you could please be back in your headquarters so we can begin at 1:15, that would be wonderful. Investigator Gaither will release you until 1:15. If you'll just come back, please don't discuss testimony anybody except the attorneys in this case, okay?
Yes, sir.
All right. All rise.
Okay, ladies and gentlemen, lunch break.
All right, ladies and gentlemen, please be seated. Our jury has left us. We are in recess until 1:15, okay? All right.
And we are in recess until lunch. I didn't leave you guys. I'm still around, ladies and gentlemen. I am just following up on another story. And we may have to bring you on location. Stand by. What did you think about the testimony? I mean, how many rapper boys are? So he gets another name. He's the rapper boy. What do you think about the testimony? This is interesting. Detective Gaither is helping the prosecution connect the dots. How do you think the district attorney did, and how do you think this hurts or harms Young Thug, ladies and gentlemen? Okay, let me bring myself on camera. Stand by. Okay, ladies and gentlemen. How do you think Detective Gaither did? I mean, from my perspective, it felt like if certain individuals felt like Thug was entitled or should have helped them. They felt like he owed something to them. They felt like he owed something to them. It's kind of interesting. Why would they feel like Thug owed something to them? This can be viewed too, because like how many of you grew up with people like you're really close with growing up, and this is for the fellas. You guys rolled tight in the hood, and you moved around, you ate at each other's house. Like, how much responsibility do you think another individual should have for you? Now, there's one thing, someone calls you, hey, you're my friend. I'm like, I need your help. You got nothing to do with this. But this appears that these guys feel like Thug owed them. I don't know. Right. Thug grew out of I agree with you. Thug may have grown out of whatever criminal things that he might have been doing back in the day. And again, I keep reminding people the district attorney in Fulton County, former district attorney in Fulton County, Paul Howard, declined to prosecute back then. They didn't have enough evidence. But now the jurors are being bombarded with a bunch of different individuals who may have committed acts that might have been unrelated to Young Thug. We got to see him connect the dots, ladies and gentlemen. We got to see him connect the dots. I'm yet to be convinced that the dots have been connected and they are just about to hit a home run. I get it. You want to impeach witnesses that may have come on the stand that, lied. And we know Walter Murphy was a liar. We know that Adrian Bean was a liar. a liar. We know that Tick might have lied a few times. But did they lie for their own benefit or to save Thug? Because it does appear that DK was lying to save his behind. He was ready to wear a wire. I'll do anything for you. I just don't want to do this. You're crying in an interrogation room, and you're shooting, and you're moving around, slinging firearms. Come on now. I'm not convinced yet, ladies and gentlemen. I'm waiting for that strong piece of evidence. I'm waiting. Listen. If it was some really strong evidence, they would have led with it. We're not talking about rap lyrics. And there's other individuals in the culture of hip hop that constantly glorify the behavior of bad acts from people that they don't even know. It just bolsters their own persona. It doesn't mean that Doug is co-signing all the silliness that these other people are doing, recklessness that other people are doing. It only shows that they are trying to ride on the coattail of a well-known rapper that happened to grow up with them in their community. He made it out the hood. He's traveling the world. He's doing shows with the who's who in entertainment. He is making a fashion statement around the world. And they're like, wow, this guy, he pulled himself up from all the BS and he's out here doing his own thing. I get it. But what we used to call, when I grew up, we called them leeches. Those that are trying to leech off the man's name. And we don't know if they're, it doesn't seem like he has no legitimate reason to be associated with these guys other than to say, hey, I grew up with these guys. Some of them didn't clean up their act. I decided to clean my act up, Not my overt act, just my act. We all been through that. Some have been more extreme than others, but it doesn't mean that Young Thug is, the Thug. We know Walter Murphy is a bad individual. We know Adrian Bean was a bad individual. Was. Can I say, I don't know if I should say are. Well, I can't say those who taken pleas for whatever reason, likely because they're guilty of their acts. But what does that got to do with Young Thug? The big celebrity, superstar, rapper coming out of Georgia. Yeah, he talked trash. Rappers talk. Look at the rap beef that is happening right now with Quavo, Chris Brown, and Kendrick Lamar, Drake. These are rap beefs. Some will talk more reckless than others. You listen to the lyrics on some of these songs, you're like, these guys ready to shoot up the block. They're ready to bring down the house on wax. They're doing this on wax. They doing this because they want to sound tough. Some are tough, but some are just being reckless. And of course, if I got a friend that I know growing up and he's a big dog, I'm going to try to use his name for clout. Not me personally, but I'm just saying these are some of the things, the way these young cats think. That's my man. He going to pull out. He's going to pull out. Help me. I don't know. Hold on. Hold on 1 second. Okay. Just got a very interesting update. I'm sorry I had to look at that. Oh my goodness. The fireworks are about to begin, ladies and gentlemen, but we just can't say just yet. Oh my goodness. Oh my goodness. Sometimes I have to look away. Like the judge takes his comfort breaks, I take my phone breaks. I just hope no one, and I saw your comment, Vanderveer. I just hope no one just put hands on each other. I think it's just all entertainment. We got, a lot of us invested in these entertainers because it kind of removes us from what we are personally dealing with. But I don't think Chris is going to touch Quavo. It's no, unless they want to do a celebrity boxing match. If Quavo said, "Hey, that was reckless. You smashed my girl, sweetie, while I was with her. Let's take it to the mat. Take it in the ring. Let's do it for charity." Okay, that's how we want. Yeah, let's do it for charity. I got no problem with putting the gloves on, taking in, putting, getting in the square and duking it out like men. But just do it for charity at this point. You guys got too much money to be just fighting for the purpose of fighting. What is that going to do? Now do it for charity. A 3-round match, winner takes all. Now, well, winner takes to go to their best charity. That's how it should be settled. Whenever there's beef like this, and the people are, they run in their mouth and they tough, hey, calm down. Calm down. You're about that life. Do it for a cause. Get in the ring. Get on the mat. 3 rounds. Winner takes all. That's it. Forget that. That would be so beautiful. You can feed a bunch of people. You can help causes. That's how you do it. Otherwise, it's just a waste of time. You get nothing out of that. You think Mike Tyson, Floyd Mayweather is just going to just go fighting anybody just because they said something stupid to them? Nah. Let's listen. Let's get the managers together. Let's put a plan together. Let's all make money on this. Let's give something to charity, and that's how we sell it. Other than that, it's just talk on wax. That's all. Don't get too caught up. Don't get too caught up. Miss Betty, I can't, Miss Betty, I hate when Dennis does that. I can't tell you everything. I get texts all the time. Like, do I need to just hook up my phone line to your phone line so you can know what? No, I can't say it. But it's good. Well, let me see what I can say. Let me read it one more time. I'm gonna read it one more time to see if I can say something. Let me see if I can say something. Okay. This is Tasha K related information. You guys don't want that. We're not talking about that right now. I just got a little update. That's all. That's all. Just a little update. It's nothing. It's not related to YSL Young Thug. Okay, so ladies and gentlemen, I saw the poll that was taken on the Shade Room, and I knew the outcome was going to be what it was. I'm like, why Shade Room? Why you gonna do that? You're being shady again. No way that I heard Chris's verses. It was powerful. He emptied the whole clip. He emptied the whole clip on Quavo. It was just incredible. And Quavo came back. It was okay. It was mid, but it wasn't. You had an R&B dude come out and just, oh man, it was R&B dude. Miss Betty, I don't want to haze you. I don't want to haze you. G5G. I don't. Miss Betty, I ain't trying to haze you. Come on, Miss Betty. Miss Betty, come on. You know I ain't gonna do that to you. But yeah, I saw the poll. I wasn't surprised at the outcome. Meanwhile, Mr. Curtis was rooting for the underdog. He knew what he was doing, but I also know that it wasn't going to end well for Quavo. We'll see. We'll see. If I had to, let me see. If I wanted to see a rap battle, who would it be right now? A real rap battle that can really. I'm gonna tell you something. I'm gonna tell you one rapper that is so underrated. He hasn't gotten the recognition that I feel like he deserved. That rapper is King Los. King Los is one of the hottest rappers in hip hop. His battle game is superior. I want to see King Los go up against Chris Brown. Now that's a battle. Well, no, not really, because he's R&B. So that I wouldn't play him like that. Okay, I want to see King Los go up against King Los is up there. King Los. Google King Los. Don't be hooing. You know who King Los is. King Los. Los. Those who know. King Los is one of the hottest that ever did it. King Los and KRS-One. That's it. That's who I want to see. King Los and KRS-One. But KRS-One will probably not touch him because that's the OG. He ain't gonna do that. But King Los is really good. I seen him on Sway in the Morning, and he held his own. There are not too many great rappers out there that write their own music. There are not too many great ones out there. But King Los is one of them. I agree with you, V. I agree with you. But he's also writing a lot of stuff behind the scenes. But he's a guy you need to check out, and then tell him I sent you. Tell him I sent you. He's actually I think he's married to Lola Monroe, who was signed to Taylor Gang. You guys remember Lola Monroe? Ethiopian rapper, but she was signed to Taylor Gang, and she was pretty good too. But she was good. And I ain't trying to say she should have focused on modeling, but she was she wasn't as good as some of the girls that were out back then. But I get it. 50 Cent know what he's doing. 50 Cent knows what he's doing. Okay, let me go to ladies and gentlemen, stand by. I had to go to the social let me go to IG real quickly and see who's checking in over there. Okay. Let's see who's checking in over on Instagram. I see you, Harlem Legend TV. I see you, Sean Bear. I see a bunch of you. There's a lot of names. Wolfgang. You know. Who else we got over here? A lot of you in there checking in. I see a bunch of you guys. A lot of you. I see you. I see you. Let's see here. Let's see what else we got over here. Sit with ya. I see ya. We doing our little shout outs. Tiffany, I see you, Tiffany. What's good, Tiffany? What's good? Let's see. The plainest Jane. Where the heck you been at, the plainest Jane? Where you been at? Y'all go follow the plainest Jane. She doing her thing up there in the DMV. DJ Corrupt. Another goat. Another goat in the business, DJ Corrupt. I see you. Okay. It's a lot of names. Names. Oh, shout out to the Bam, Bambi, loving hip hop. Bambi, what's good? What's good? What's good? Lish 2X, rapper Lish 2X. She be doing her thing. Lish 2X, New York City in the building. Yes. Okay. Okay. We're okay. Okay. I see you. We're gonna go to Twitter now, real quickly. We're going to Twitter. Let's see who's checking in from Twitter. Let's see who's on Twitter here. We kind of circling and spinning the block and so forth here. Okay. Of course, shout out to Cardi B. Shout out to Cardi. See, you're trending over again. You're trending. Let's see who else we got over here. Yeah, we are on YouTube. Excuse me, on Twitter Live. I see you. Let's see. Let's see. We got some comments over here. Let me see. Let me go in there. Hold on. Okay. Okay, just leave your comments. Leave your comments here. Okay. Stand by. Just type in. Okay. All right. All right. There we go. Okay. We might drop a poll later on. We might just drop a poll later on. We will be back. I'm going to take a 15-minute comfort break, but let me take you guys. Let me see if I can bring you back into New York City real quick. Stand by. Okay, ladies and gentlemen, there has been an indictment returned on Brendan Paul. Brendan Paul is Puff Daddy's personal assistant. We saw Brendan Paul being arrested in Miami last month as it related to drug possession, and his bond wasn't set at too much. It was under $10,000. $10,000. However, he's been indicted on a felony. Now, my guess is they're trying to put the pressure on Brendan Paul to flip on Diddy. How would that look like? What would that look like? So yes, Brendan Paul has been indicted and he is now facing a felony charge of drug possession. How does that look for him? Will he flip on Diddy? Will he tell on Diddy? Does he have anything to tell on Diddy? Well, ladies and gentlemen, he has now been indicted by a grand jury and he may cooperate. His attorney, Mr. Bieber, not Justin Bieber, has stated that he will not fight the case in the media and that the public must wait to see it play out in the courtroom, the court of law. So how that looks, I don't know. But this is just in. Brendan Paul, a former player of the Syracuse basketball team, has been indicted on one count of felony drug possession. What does that look like? We'll see. Also, not former, that was a slip. Current President Joe Biden has just signed a bill to ban TikTok in America. We saw the House and Senate pass the bill. Now it went to the president's desk and he has signed the bill. And now TikTok has been banned in America. The CEO of TikTok has responded and said, the law is on our side and we are going to appeal. The Constitution is on our side. We are going to appeal. Well, I have a question. If you're a citizen, the Constitution applies to U.S. citizens. So let's see how this plays out. So yes, TikTok has been banned in America. So let me go. Listen, let me say this. If you guys got content on TikTok and it's only on TikTok, you might want to go ahead and retrieve that content while you still can, because it's been banned in America. That means they can't do no business in America. That means any store that you have on TikTok in America, you won't be able to do any commerce. It's been banned. That is interesting. They banned TikTok. The government wants TikTok to sell their company to an American company, because American companies have to follow American laws. So, with that said, what will TikTok do? And how soon will they do it? Because this definitely will impact how many on social media will conduct business using that particular social media platform. But guess what? There's still fan base. Shout out to the brother Isaac Hayes Jr. or the third, who has fan base, an American company that has to follow the American laws. So while this is bad news for those who are using TikTok, I don't really use TikTok. I'm on TikTok, but again, it might be overkill for me right now. But a lot of you are using TikTok. A lot of you are using TikTok, and I think that it may or may not be a good thing. I don't know. I got to look at the bill and I got to look at why it has been so hard fought by many to keep TikTok, people having access to TikTok. With that said, ladies and gentlemen, let's see if there has. Let me go and see if there has been any other updates as it relates to the fight that will be ongoing for TikTok. Because if they can't do business in America, is that really bad for America, or is it more bad for Mr. Chen and his company? We have to see. Stand by. Ladies and gentlemen, breaking news, breaking news, ladies and gentlemen. Breaking news. Put a 1 in the chat if you can hear me, ladies and gentlemen. Put a 1 in the chat. We are going to give you the breaking news development in the case involving Mr. Ernesto Williams, the former husband, still the husband of Steve Harvey's co-host, Shirley Strawberry. Mr. Ernest Williams has been, in fact, indicted on a count of a RICO, racketeering, and bigamy. To get the details, please go over to Pam Esquire, the intellect, right now. The story is a breaking news development in the case involving Ernest Williams. Some call him Nasty Nesto, but you call him, that's what you call him. But go over to Pamela Esquire right now. She is breaking it down right now. We are still covering YSL, but we'll be over there as well. So please stand by.
this is why I'm asking now, because Investigator Gaither's on the stand regarding a January 10th meeting between Investigator Gaither and Kenneth Copeland. We brought that up a couple days ago, and we haven't heard back from the state. So I am checking on that. And also, Your Honor, the second thing is there were yesterday on direct, Investigator Gaither, in response to Ms. Love's questions, indicated that she had spoke to Terrion Moody on this case, indicated that she had spoke to Cornelius Davis about this case, and had indicated that she spoke to Christian James on this case. Those are three of the individuals that are in the car with Dexter Montgomery. In the discovery provided, at least to my knowledge, there's no police reports documenting this or taped conversations documenting this. Now, I'm not denying that there's a possibility that they weren't documented, but I just want to make sure that there's no documentation that is missing.
Okay. Ms. Love, addressing that point number one. Is there any police report in regards to that conversation?
Your Honor.
Did you check and make sure that there was not any?
I did not.
That was receptive to that, or
I am receptive
responsive
to
to
it.
that particular issue?
I didn't get asked that question until now. I can ask. We did not have one. I know that, as you can see in the video file, when Investigator Gaither is talking to Walter Murphy, there are images that we don't have and didn't have and couldn't find. The images of the still shots from the surveillance footage, but I did not ask the question that Mr. Sharp just asked. I can inquire now. That's the first time that he's brought it to my
We
attention.
asked about that a couple days ago.
He did.
About the,
January 10th conversation.
that was different. Now, when he asked me about the January 10th conversation with Kenneth Copeland, I did ask her that.
Does it exist?
She said that to the best of her recollection, she talked to him that night, but she doesn't know whether or not she's on camera. She said she seems to remember talking to him.
Was it memorialized in any fashion other than what we see on tape?
Yes, so I didn't ask that.
Okay, you can ask her that, and can you ask her if there are any reports from the other three individuals?
Yes, I will ask her that.
Did you ask her that already, or what?
No, I didn't ask about the other three individuals. This is the first. I'll go ask about the other one now. Just
All right.
1 second, she's outside.
Okay.
Oh, she didn't ask. 2 moments. I'm missing my phone. I think I left it in the room.
Yes.
Mr. Sharp. Your Honor, may I ask Mr. Sharp to accompany me so that I can
Sure.
set at the same time?
You're gonna need the phone. Yeah. It's either that or cry.
Witnesses for immunity motion, I think.
Yes. Investigator Gaither, please.
No value add.
All right, Sergeant Ingram, summon our jurors, please, sir.
Yes, sir.
All right, ladies and gentlemen, please be seated. All right, thank you, Sergeant Ingram. All right, madam, you may begin when ready to continue examination.
Thank you, Your Honor. Investigator Gaither, I have been calling you Investigator Gaither since we started. What was the last title that you held at the Atlanta Police Department?
Sergeant.
All right. My apologies for that.
I'm taken.
Previously, you testified about what has already been admitted as State's Exhibit 70 Bravo Bravo and 71 Bravo Bravo. And I'm going to bring them to you with the court's permission. May I approach?
You may.
Thank you. Showing you 70 Bravo Bravo and 71 Bravo Bravo. I am going to show you what I have now marked for demonstrative purposes, Your Honor, as State's Exhibit 110 Bravo Bravo and 111 Bravo Bravo. I have shown these to counsel for the defense, Your Honor. So I'm just going to approach with the court's permission.
You may.
Thank you. Showing you 110 Bravo Bravo and 111 Bravo Bravo. Are those angles of the intersections shown in 70 Bravo Bravo and 71 Bravo Bravo with the street signs actually showing?
Yes.
And are they accurate representations of the intersection as it looked
Yes.
in April 2015?
Yes.
Your Honor, the state tenders for demonstrative purposes only, State's Exhibit 110 Bravo Bravo and 111 Bravo Bravo.
No objection.
All right, states 110 Bravo Bravo and 111 Bravo Bravo are admitted for demonstrative purposes. To be shown.
Thank you, and I will hold up and ask you to describe for the jury just what it is we're looking at in State's Exhibit 110 Bravo Bravo.
That is Harper Road, looking eastbound.
And when you say Harper Road looking
Here.
eastbound,
This is Harper Road. This is Browns Mill Road on here.
Harper?
No, that's Browns Mill. Yes.
Is this way.
Well, looking at the picture, you're facing it. That's eastbound.
So on 110 Bravo Bravo, showing you the old-fashioned way, looking at the picture, Harper eastbound is the way that I'm pointing.
I stand it's a formal question. You can rephrase.
The vehicle that's in the picture is facing westbound. The opposite way, looking at the picture, you're looking at it. Car is facing westbound.
Thank you. And what area do we see in 111 Bravo Bravo?
That's Harper Road as well, at the intersection of Brownsville.
And is this a four-way stop, two-way stop, or something else?
It's a two-way stop, just on Harper Road. Brownsville Road doesn't have a stop sign or stoplight.
I'm now showing you what has been marked as for demonstrative purposes, State's Exhibit 103 Bravo Bravo, which I have shown to 103 Bravo Bravo Alpha, which I've shown to the defense but can show again. Does anybody wants to see it? Would you like to look? Because I think I've invited people.
Yeah, I don't believe that one was shown.
We can move past it. Miss Sergeant Gaither, during the time that the gang unit became involved in the back and forth between If Gang and YSL, did you and your partner have an opportunity to look at the social media page for Demekion Garlington?
Yes.
Madam, can you speak up to?
Yes.
And around January 26th of 2015, did you locate a video, or did you locate a video posted around January 26th of 2015 depicting Mr. Williams displayed on Mr. Garlington's social media page?
Yes.
Showing you what has been marked as State's Exhibit 112 Bravo Bravo. Also on the thumb drive that you identified earlier. Before I tender it, I'll bring it over. Have you had an opportunity to look at, and is this the video that you all located on Mr. Garlington's social media page?
Yes.
And was this from January 26, 2015?
Yes.
And is this an accurate reflection of the page as you all captured it?
Yes.
You know, okay.
All right, I'm going to now show it to counsel for the defendant.
Okay. All right. Gotcha.
Does the video depicted in State's Exhibit 112 Bravo Bravo have sound to it?
It does.
And does it have more than one voice?
Yes.
Do you recognize the voices?
Mr. Williams and I want to speculate on the second person, but I did.
Your Honor, State Tender State's Exhibit 112 Bravo Bravo as evidence.
Any objection states 112 Bravo Bravo.
Yes, sir.
Basis.
Foundation is your repost.
Your Honor, the witness has laid
Y'all come on up.
this.
Come on.
Sergeant Gaither, I'm going to ask you a few more questions about State's Exhibit 112, Bravo, Bravo. Did you recognize the person who was depicted in the video visually?
Yes.
All right. And did you recognize the voice of the person depicted in the video?
Yes.
Was the video obtained from a public social media site that was accessible to anyone who is looking at that site?
Yes.
Okay. We will come back to that. I just want to ask you a few more questions about your investigation into Dexter Montgomery. Did you charge Walter Murphy in relation to, did you speak with Walter Murphy again after the August the 18th of 2015 interview that you did with Walter Murphy, his attorney, and Detective Dennis?
Outstanding question.
In the February the 16th, 2016 proffer that you did with Walter Murphy, did you obtain any more information than you had gotten in the other two interviews you had with him?
That would go to the best evidence rule, Your Honor.
Your Honor, I believe that I can ask the witness about the type of information she obtained.
I would object. Same objection.
I'm sustaining the objection.
Yes, Your Honor. While you were speaking with Walter Murphy in the September 16, 2016 interview,
August or September?
I'm sorry, February 16, 2016 proffer, was that a meeting that you requested between yourself and Walter Murphy?
No.
And where was that meeting held?
I was asked and answered.
I sustain the
It was
objection,
not,
sir.
but okay. As you held that meeting and asked questions, was there interaction between Mr. Murphy and his attorney?
Yes.
The recording speaks for itself.
I'm gonna sustain the objection on other grounds, Mr.
Okay.
Steele.
Okay. Prior to that, February the 16th, 2016 interview, did you take out charges for Walter Murphy as it related to the Citgo and the Browns Mill incident that occurred back in April, on April 12th of 2016?
Ask and answer is on the recording of July 15th.
I sustain the objection.
Would you tell the jury, with respect to the charges that you took out, why did you classify the acts that occurred as criminal street gang activity?
That is irrelevant.
I sustain the objection.
Your Honor,
I sustain the objection, madam. You can move on or ask something else.
would you tell the jury what aspects of that shooting that occurred on April 12, 2016 factored into, based on your knowledge, training, experience, and learning as an investigator and gang expert, what aspects of that incident caused you to classify it as gang activity?
Objection, Your Honor.
Basis.
Simply rewording the same question, same objectionable question.
I'm gonna overrule the objection. Mr. Steele, do you have an objection, sir?
Under Parcell, it goes to the intent, which is not for this question to be answered.
I sustain the
Your Honor,
objection.
this is an expert, and this is the
I
portion.
sustain the objection, please.
When crimes are committed, and the persons committing the crimes make no effort to conceal their identity, does that hypothetically?
She hasn't pondered the question quite yet. Let her finish and then I can make a decision.
And Your Honor, at this point, since the court has qualified the witness, I will be asking a hypothetical.
And that's my objection, it's a lay witness at this point, and it's not proper to ask a lay witness hypothetical.
I stand in
Your Honor, I
objection.
have to demarcate, and at this point, I'm asking that the court recognize and instruct that we are demarcating and asking expert opinion.
You all approach.
Sergeant Gaither, as we are getting a last exhibit, and Your Honor, we are intending to bring back the one that we tendered a moment ago with the court's instruction.
Which is? Which one, madam?
The 112 Bravo Bravo
Okay.
that takes out the portion of the second speaker.
Are you trying to tender it at this point in time, madam?
Your Honor, we would tender that exhibit with the caveat that,
With the court's earlier ruling?
yes, Your Honor, yes.
Any further objection, counsels, to states 112 Bravo Bravo?
Yes.
Basis. Okay, Ms. Love, show that to counsel, please.
It's being redacted. And so before we display it or anything, we will show it to all the councils because that portion,
Oh, bless you.
bless you, is being redacted.
Better shake your hair there. You got Kleenex. Okay, that's good. All right. Okay, all right.
Sergeant Gaither, at the end of your investigation, would you tell the jury the persons that you took out warrants for, that you charged with actions in this particular case?
Walter Murphy and Demise McMullen.
Okay. And what did you charge them with?
I believe it was 5 counts of
I did not.
I'll overrule that objection, sir.
5 counts of criminal attempt murder, participation in criminal street gang activity, aggravated assault, possession of a firearm during the commission of a felony, possession of a firearm by convicted felons. I believe that's it.
And what gang was it that you were charging them with committing crimes in furtherance of?
YSL.
Basis, sir. I'm gonna overrule the objection.
You may answer.
YSL.
Thank you. And Your Honor, with the exception of the video that we are redacting with the court's ruling, I don't have any further questions at this time. With the court's permission to play that video after it's properly redacted and defense has had an opportunity to look at it.
Counsels, can I see you for a second, please? Just, you know. And take comfort till 3 o'clock, and then we'll come back and see where the afternoon leads us at that point, okay? All right, so we're in recess until 3 o'clock. All rise. All right, ladies and gentlemen, please be seated. Detective. 2 parts to it. One is just a picture of it. So let me see. First, let me see states 112 Bravo Bravo to begin with.
Yes, Your Honor.
This is apparently the Instagram post, January 26th of 2016.
2015.
2015.
Yes, Your Honor.
All right, let me see it.
I'm just plugging in.
It was. Is that covered? That thing covered over there? Okay. Oh, that's fine. I just wanted to know. Okay, all right.
He is putting forth himself as a figurehead. He's saying that's for me and my gang, me and YSL. Y'all need to be killed. Those words are wholly inconsistent with this notion that we just produce rap music for the good of everybody. And so, Judge, given that the speaker of the snitching bitching comment is doing nothing but co-signing the main message that Mr. Williams is speaking, and given that the video itself was publicly posted, we would ask, in light of the cases that we have cited, along with United States versus Bagley, Bagguley, at 1987 US APP Lexus 18712, a Fourth Circuit 1982 case, as well as in United States versus Bagley, the court said that the contentions of the appellant raised seemingly disparate concerns, but at least the first four of them converge insofar as they allege the authenticity and reliability of the tapes. The first contention, that identification of all speakers is necessary before tapes are admitted, refers to one of 7 requirements often enunciated by courts for the admission of tape recordings. But the primary aim of these requirements is to give the assurance that the tapes are accurate. The goal of accuracy is sufficiently satisfied even when all the speakers are not identified, as long as relevant speakers are. In the challenge recordings in Bagley, the court found that the more relevant party was the caller, who in each case was an identified member of the conspiracy. And insofar as the conversations may be deciphered to involve the heroin scheme, the names of the recipients of the calls were not critical to the tape's accuracy or their relevance. Therefore, the trial court properly admitted them despite the failure to identify every party. And this is a Fourth Circuit case applying a test from the Fifth Circuit. Bagley is.
Prior to the new evidence code?
Bagley is prior, but Hampton is in 2022, and Hernandez Garcia's is 2013. Of course, the new evidence code came out in 2013. And we also have others from after the new evidence code as well. 2014, United States versus Reeves. That site is 742 F 3rd 487, 501 through 5.
Yeah, I'm thinking of the 11th Circuit.
This is the 11th Circuit. United States versus Reeves is the 11th Circuit, Your Honor.
And what is that?
The site is 742 F 3rd 487 at Penn site 501 through 502. And in Reeves, the court cited Biggins, Biggins, which was a Fifth Circuit case. In Reeves, the court said that the government carries the burden of proving four things, the most relevant of which is the identification of the relevant speakers. But even if one or more of the requirements has not been satisfied, if there is independent evidence of the accuracy of the tape recording admitted, we shall be extremely reluctant to disturb the trial court's decision to admit the recording. They point out that under the federal rules of evidence, an opinion identifying a person's voice based on hearing that voice at any time under circumstances that connect with the alleged speaker can satisfy Rule 901. And they cited Fifth Circuit 1979 case for that proposition. So for our purposes, as we've alleged and stated from the beginning, the person that we identified in the overt act listed in the indictment was Mr. Williams. His words were the overt act that we alleged in the indictment in Act 26. Mr. Williams is the relevant speaker. His words are the relevant words, and the persons who are behind him talking are simply co-signing.
Okay, you said that twice now. Okay. at least
I won't
it's-
say it again.
All right, so let me hear from your colleagues across the table here. Mr. Steele, you want to start out, please?
Your Honor, in both Hernandez Garcia, sorry. I apologize. In both Hernandez Garcia versus State 322 Georgia Appeal 455, 2013 case, Division 4A. What our court said is here the witness called by the state to authenticate the recordings and transcripts testified that she had heard the conversations as they occurred and were recorded, and she had transcribed the conversation as she heard them and they were being recorded, and that the transcripts accurately reflected the recorded conversations. United States versus Reeves, R-E-E-V-E-S, 742 F3rd 487, 11th Circuit. Our 11th Circuit said under Division A, in order to introduce a recording at trial, the government must establish that it is an accurate reproduction of relevant sounds previously audited by a witness. Plainly, the government carries the burden of proving the competency of the operator, the fidelity of the recording equipment, the absence of material deletions, additions, or alterations in the relevant portions of the recording, and that the identification of the relevant speakers. But even if one or more of these requirements has not been satisfied, if there is independent evidence of the accuracy of the tape recording admitted trial, we shall be extremely reluctant to disturb the trial court's decision to admit the recording. These are all foundational. That's why I didn't mean to turn my back. I came back to the computer. That's why you told me over my objection, I could not get in the lifestyle recording. It's a song by Rich Gang. When I had Trontavia Stevens on the phone or on the stand, you said to me, he doesn't know. You said you can get it in with someone else. It's Mr. Williams' words. You're showing that it's not a member of a gang, that it has a real lawful purpose, but you have the wrong witness.
Okay, why wouldn't, I'm just asking this question, Mr. Steele. Why wouldn't when it boils down to it, the statements purportedly made by your client, why wouldn't those be admissions of a party opponent?
They need to be identified when they were made. It's a repost. What you're being shown is a repost. Are they the same statements? People change things all the time. Like the state was going to redact here. In the background, we start out with the state saying, you only hear by other identified persons. You clearly hear the person saying, I'm going to lie on God. Snitching, I'm not going to say it, but BIT blank ACHES. F and then the N blank GGA. That's as far as I can blank you. So help you God. It's 17 seconds and there are multiple speakers. It's not just two speakers, there's multiple speakers that right now the state may be able to get it in. It's just like you told me. I'm not saying this may not be evidence that's important to the case. What I'm saying is there has to be the same foundation that the state lays that you're making me lay, and that's what the case law supports. Now, if you let it in, an appellate court, they may say it was error, harmless error, it wasn't an abuse of discretion, it wasn't abuse of discretion. We understand that, but we're here now. The state cannot lay the foundation. They need a different witness. They don't have the time, just like in the last series of jail calls. You had to say what the date was. The witness was able to provide the dates. They have the dates here. They know a reposting. They don't know if it's the accurate statements. They are taking something off of the internet. It is exactly what you have told me. In the other cases that the state has cited, the witness was a member of those conversations, heard them live and said, those are the conversations. I don't know the other people, but that is exactly what was said. That goes to weight. Here, they don't know what was said. They know it's a repost. That is my statement.
All right, sir. Thank you.
Thank you.
Anybody else? All right, let me take a few minutes out and I need to take comfort and I'll think about it and we'll come back.
Your Honor, can I get the court?
No more sex, okay? I'm gonna take my break. Everybody should, we're in recess.
Okay, ladies and gentlemen, as you can see, Madam DA Love was about to circle the block again. The judge said, no. I'm taking my break. Whatever you have to say, it will have to wait. Am I straight? So here we go with the rap lyrics that is likely to be played in the courtroom. The judge has to ponder the new ruling that came down from Georgia Supreme Court, and see whether or not allowing that evidence in will deny the defendants a right to a fair trial. So with that said, let's see what happens. The judge is on a comfort break, and so am I.
I'm sorry, who are we missing?
Matthew Senior, but we got.
Okay.
Junior.
Oh, Junior's here though. Mr. Matthews Jr., I apologize.
The judge
Are we
is
still
about to
waiting
make an
on
important
Mr. Matthews Senior?
ruling.
I'm sorry? Oh, you're good. Okay. All right. Thank you, sir. Appreciate it. All right. Okay. The court's had an opportunity to kind of consider the issue presented to it as to the exhibit. That being states 112 Bravo Bravo, the digital media of the incident involving the posting of January 26th of 2015. I'm going to sustain the objection as to foundation at this time. However, much like many of the rulings I've made, they're subject to reconsideration. In this particular circumstance, I believe that it is the opinion of the court that the original video as presented would at least the source would have to be at least identified for the purposes to make sure that there were no alterations of that particular video. I don't know whether or not they are, but I think that'd be part of the foundation in this case. So, for example, when we haven't had testimony of this quite yet, if it can be shown that this particular video came from Mr. Williams' Instagram page or some other social media site, and it's public and posted, and then it was re-grabbed and reposted, then that would finish the foundation for in the court's opinion. And the other issues that the court would take up at that point in time as to what it would play and for what purpose. Okay, so I'm going to sustain the objection right now, but if you can lay more foundation another time, I'll reconsider.
No
it,
more
okay?
buts.
Yes, Your Honor, and to understand, Your Honor, is the court saying that only postings of a party opponent on the party opponent's website can be?
No. It has you have multiple issues with this particular piece of evidence. We haven't gotten to the reason that you want to put it in. That's separate. Okay. The first part has to be the foundational aspect of, is it true and is it authentic? So in order for you to do that, you need to show where the original posting came from, so there's no alteration of that particular post. I would need to see that in order for me to kind of make further decisions on whether or not that particular statement is admissible. I mean, so I'll get to that, but I think that if you can show that where it came from to begin with, that there's some reliability that, hey, it came from Mr. Williams' website or a post from Mr. Williams, then I'll reconsider it at that point in time. I just haven't heard any testimony about that.
I didn't know if the court saw at the bottom, it said at Thugger1.
The judge made a ruling
to Mr. Williams' website.
I understand that.
And so,
but it's still a reposting.
And in doing so, Mr. Garlington was adoptively admitting Mr. Williams' words. As Mr. as our evidence
See, the judge made a ruling.
book says, statements of a party opponent are admissible without presentation of any predicate or foundation. The definitional exemption for individual.
Where's that?
It's on page 463. It's in 24-801 D2A. It's the
24-8 what?
801.
24-8 dash what?
801, Your Honor. Delta 2 Alpha. And it is under the heading Foundational Factors. And for the court's edification, it's the 8th edition, page 463, the 3rd paragraph down.
Well, I would have thought he would have researched this on that break. He made a ruling, and now she's re-arguing her motion, objection to the. Wow, this is crazy.
What paragraph? I'm sorry.
It is paragraph 3 that starts with statements of a party opponent are admissible without presentation of any predicate or foundation. The definitional exemption for individual admissions is extraordinarily broad, with exemption for individual admissions having almost infinite breadth. In addition, an admission of a party opponent needs no indicia of trustworthiness to be admitted. The party admission must be relevant, and the party admissions are not subject to the personal knowledge requirements of federal
Okay, the question
rules
is,
of evidence
who determines
602. In
how
addition,
relevant it
courts
is?
recognize the freedom that admissions enjoy from, quote, the restrictive influences of the opinion rule. They go on to point to the fact that the District of Columbia Court of Appeals explained the generous treatment that the introduction of party admission receives. Party admissions differ from most out-of-court statements in that their admissibility does not require the demonstration of guarantees of trustworthiness, but is based rather upon the identity of the speaker. Therefore, party admissions do not require foundations to be admissible as substantive evidence. They need not have been made on personal knowledge and may be in as a statement is fairly attributable to the party. It makes no difference whether
Who
the
determines how
adopting
fairly
party
this is attributed
had
to the
any
party
personal
being her?
knowledge of the truth of the matters mentioned in the statement. And then it goes on to
All
show.
right. That's plenty. All right, Ms. Steele, I'll give you the last word because it looks like I may have read too early. So,
wow.
I don't believe you read too early. Statement of a party admission has to be an admission.
party opponent.
An admission by a party opponent, I thought.
Wow.
Admission by a party opponent. Yes, sir.
An admission has a specific text and connotation in law. It's different than a confession, which admits all elements. An admission admits some of the elements. Here, this is a statement. The state still has to be bound by the foundational requirements that you have sustained the objection.
Okay, stop. Please,
yes, sir.
Please don't go back to that. I have to make them on an individual basis. All right. So, why wouldn't this be an admission of a party opponent, your client, if a jury chose to believe it?
Because 3 reasons, and you've already said it. You don't have a date.
But it looks like from looking at Carlson and 24-8-801 D2 alpha, that's what it indicates here, that that statements of a party opponent are admissible without presentation of any predicate or foundation.
Because it's not an admission, so you still need the foundation.
Why wouldn't it be an admission? If it's believed by the jury for what it stated in the statement, it goes to whether or not your client's a leader. It goes to whether or not he has control. It goes to several other purposes that the state mentioned earlier in terms of his relationship to YSL, intent. So if the jury believes that, because that's certainly within their purview, but why wouldn't it? I mean, why wouldn't it be a party admission by a party opponent for that reason?
Because the state is saying they charge in an overt act that this statement was made, reposted on the 26th day of January 2015. There's no evidence of that.
But it looks like. But I'm sorry. Go ahead, sir. I apologize. Go ahead. Go ahead. I'm sorry. Go ahead.
My position is it's not an admission without there's some sort of context. This was said for this reason, to stop people from cooperating, or this was said for this reason.
But that's what the jury. That's what the jury needs to decide on that issue.
Foundational requirement, like you said. I believe a foundation still is.
Okay. While I did say that, Mr. Steele, it looks like that. Of course, I have to look at things in the light of what you all tell me, and also the statutes and the law applicable. But it appears that it looks like from statements of a party opponent are admissible without presentation. If I believe that the statements in 112 Bravo, the digital media from January 26, 2015 are in fact an admission against interest.
I don't believe,
or admission of a party opponent, I should say.
I don't believe that it fits in that category because we don't have any of the date that it was made. If it was truly that statement of Mr. Williams, I still say that the state, they started out with, it's all Mr. Williams' statement and there's nothing else said except yeah, and indiscernible. That's wrong. Then they started out with, they don't have to identify the speakers. I believe that's wrong. And now they are at a position where they don't have to lay any foundation because it has to be an admission of a party opponent.
But it looks like under 24-8-801 D2A that it's not required.
Okay.
It's not required.
Well, then I need.
And I'm looking at the statute right now, and it says, admission shall not be excluded by the hearsay rule. An admission is a statement offered against the party. A statement means an oral or written assertion or a nonverbal contact of a person is if it's intended by the person as an assertion. Your client is allegedly making a statement in this particular video, which arguably is an admission by a party opponent for what the state is claiming.
I mean, they can claim anything.
26, as well as count 1. So, I mean, and that's for the jury to decide, but whether or not they want to take it as that. But it appears that
you can't unring the bell once they hear it.
D2A correctly, that the foundation has been met.
Well, then I would like, I didn't know about this when you broke. If I would have known about this issue, I would have done it over the break. I just learned about it. I'm assuming the court learned about the state's new position. I'd like time to look at it because my memory is this is not an admission, but I have to get you the cases. I can't cite a case to you off the top of my head. I apologize.
No, I mean, look, I'll give you 5 or 10 minutes if you can find me a case that says it's not a statement against interest or a statement by a party opponent, but admission by a party opponent. I'll take that into consideration, sir. Okay.
Thank you.
All right. So I'm just gonna pause for just about 10 minutes, and I'll go ahead and let you all confer about that. Okay.
True. This case will go on until 2026. Allegedly. With that, ladies and gentlemen, I want everyone to stay in place. We're going to recess in place until Mr. Still finds the case law.
Where's Mr. Steele? Oh, there he is. Okay, all right. Let me go ahead and just as an opening kind of to the court's addendum, just tell you that I'm only going to consider the statement and want to hear argument as to whether or not it falls within 24-8-801 D2A, because from doing a little more research, if it's an admission against interest in the statements in a criminal case, and this is the case law, and I'm looking at Anderson versus the state, 360 Georgia App 291. If it's in a criminal case, exposes that the declarant to criminal liability showing must be shown of the corroborating circumstances that clearly indicate trustworthiness of the statement. So my original ruling would stand on that issue, that you'd have to be able to show where it came from, even though generally a repost can't be changed, but I don't know that. So I would have to hear something about that. So I'm not going to take it as a statement against interest. I will, however, hear any argument as to whether or not it still falls within an admission by a party opponent.
Does the court have a preference for when each side speaks?
Okay, go ahead.
So, Your Honor, under 24-8-801 D2A, admissions by party opponent, I believe the question raised was whether it was an admission. 24-8-801 defines statement as an oral or written assertion. In this particular case, there was an oral assertion that if you lie to your folks and get in court and tell the truth, you need to be killed. That's from me and YSL. But 24-8-801 also defines a statement as nonverbal conduct of a person. The nonverbal conduct was capturing himself saying that, memorializing the assertion, the oral assertion that he made. So the exhibit itself qualifies as a statement because it contains both oral assertions and nonverbal conduct. And so therefore, under 24-8-801 D2A, it is a statement of a party opponent, which is admissible without the presentation of any predicate or foundation. Additionally, Your Honor, 24-8-801 D2E would make anything said by the people behind him who are co-signing as to what he is saying, co-conspirator statements. They are literally—
We don't know who they
right.
are, so.
Right. And so what we hear happening by the primary and only relevant speaker, and that being the defendant Williams, is as he is saying, y'all need to get killed, bro. That's from me and YSL. There's no rejection or rebuking or anything like that of the snitching bitching statements. So essentially, he's adopting those as his own as well.
He being Mr. Williams, so purportedly, right?
Yes.
Okay.
And so we primarily stand on the admissions by a party opponent. And as to the commentary that is also heard, we would argue that Mr. Williams has adopted those, and that any argument to the contrary goes to the weight and not the admissibility of the statements. And the jury is the proper entity to weigh that statement.
All right, madam.
Thank you.
Mr. Steele.
Your Honor, I found a case. It's United States versus Rodriguez, which is ROD-RIGUEZ.
One more time.
Yes,
Is
sir.
it RODRIGESZ?
RIGUEZ. RODRIGUEZ.
Yes, sir.
And it's 427, Fed, which is FED period, appendix APPX period. 784.
One more time. I said
Yes, sir. 427.
427.
Fed,
I'm
FED
sorry.
period, appendix APPX period.
You said Fed appendix.
Yeah, FED period, APPX period. 784.
All right.
It's in division
Let me see if I can find it.
C1.
Hold on 1 second.
And is this a 2011 case?
Yes.
It looks like it's 2011. Is that correct, Mr. Steele?
Correct. May 25, 2011.
That would be before the new evidence code.
Right,
took
in
effect.
Georgia, but it's 11th Circuit, so we adopted their evidence code. That's what we did. So this would be the law that from the 11th Circuit.
All right. So what section are you asking or inviting my attention to?
C and then 1. It's maybe halfway down in the opinion.
C and then 1. Okay.
Yeah, so it starts with C and it's titled, "The District Court Did Not Abuse Its Discretion in Admitting Evidence." There's a paragraph explaining it and then it goes into 1.
Hold on 1 sec, sir. Is it the letter C in terms of,
Yeah.
okay, hold on 1 sec.
It's in, under Roman numeral 3, it says discussion. And then it starts with A, B, and then C, and then 1.
I'm with you.
Okay, and then, I mean, it's a short passage, we can read the whole thing, but I liked it because it targeted both what you said to us, and I heard what you said after I found it, but 801 D2A as well as 801 D2E, that was in the same case. And in the third paragraph of Division 1, it states that the district court also acted within its discretion when it concluded that circumstantial evidence coupled with Rodriguez's self-identification authenticated the telephone conversation sufficiently to satisfy Federal Rule 901, which is corresponding to Georgia 24-9-901, which provides that the requirement of authentication or identification as a condition precedent to admissibility is satisfied by evidence sufficient to support a finding that the matter in question is what its proponent claims. And that's what the court just found, and what I've been saying, they don't have, to my knowledge, right now, any evidence that this repost is what it was originally. They don't have the date on the original statement. So that is my position again.
we don't, in 24.801 D2A, which is our statute, it has no requirement of date and time as Mr. Steele is asserting.
Authenticity.
And
That's different. That's different. Authenticity is different.
Exactly.
Authenticity is different. It's 901. Okay.
I'm not saying.
But, okay, but Mr. Steele, that would only be, for example, if I couldn't, or nobody could make out that that's purportedly your client, that would be indicia that it's not reliable, okay? But there's nothing in there that's shown that the postings have been distorted. It's not readable. It's grainy, whatever. So there's sufficient indicia that that's your client. I mean, I would argue that from looking at what the state has tendered or proposes to tender as in this exhibit 111, I should say 112, Bravo.
I'm not claiming that someone reasonably did not say this. I'm not claiming.
But that goes to 901, and it goes to whether or not it could reasonably be that it's your client and there's other and it's reliable. So.
Is there something beforehand? Is there something after? The words change. The other speakers are identified.
But there's nothing in there that would indicate to the court that has occurred. If there was, I would certainly take your argument, and that would be more applicable. But I understand, sir. I'm gonna basically overrule that particular. I'm not gonna overrule it, but I'm gonna go ahead and I'm considering it for the proposition it is.
Your Honor, in regards to the statements of other people on that video, those are not admissions by Mr. Williams. So are those being redacted? I recall, despite what was said at the bench, that the tape actually, I think at one point someone says this is from YSL, B word or something like that. And those are not words of Mr. Williams.
Okay, but Mr. Williams, if you believe the state's argument and the jury can decide for themselves, he's co-opting that particular person's statement as to the circumstances.
Well, and I have an argument about that. Essentially what we're talking about under the law is the case law refers to as an adoptive admission. And two things.
Well, no, it's different because you're still dealing with statements of a party opponent, okay?
Right, but if it's not the person, if it's not the party itself making the statement, then the only way it's admissible is if it's adopted by the party. That's what an adopted admission is. And according to the 11th Circuit and the case law, is very limited case law in Georgia, but two criteria must be met. First, the situation must be such that the innocent would normally be induced to respond to the words of the other person. And second, there must be sufficient foundational facts from which it can be inferred that the defendant heard, understood, and acquiesced to the said statement. And this is my argument. It's going to be by analogy. I'm on the phone with Mr. Steele. We're talking about the day we were in court, and then Mr. Steele says, and Max, remember that armed robbery that we did in 2020? And then he hangs up the phone. Well, I didn't have much of
That's a little different. Hey, because that's called a tacit admission. That's a statement that somebody, listen, that's a statement that somebody makes that you expect them to say. It's just like, like somebody who says, did you hit Frank? I didn't.
Well, right.
You'd expect somebody to deny that immediately.
Correct. But from my recollection of watching the post, that last part was said at the very end of the post, and there was really no opportunity to respond, to acquiesce, to do anything. And then the post ended. So my argument is, you know, I agree with Mr. Steele that it should not be admitted at all, and that's my stance. But if it is going to be admitted, the words of a third party, I don't believe that Mr. Williams' lack of chastising the person, whoever said it, in the 1 second that the clip continued before it was turned off, constitutes an adoptive admission. And so
All
that's
right.
my stance.
Thank you, sir. All right, State, you wish to be heard on that issue?
Yes, Your Honor. What is happening, as the court heard, is that the person who is echoing Mr. Williams' comments about people who come into court and tell the truth need to get killed, that's from him and YSL. They're actually echoing Mr. Williams' statement as opposed to Mr. Williams' statement simply adopting his. The other thing that I would point out is that this is a much different situation than, say, someone taking a selfie and getting photobombed unknowingly by Mr. Brown standing behind me until I look at the picture. Mr. Williams has a camera up to his face. He is video recording himself, and it's audible to a listener that words are being spoken. He did not have to keep that recording. So his nonverbal conduct was the recording of himself and the capturing of that echoing or that co-signing of the person who is signing on to what he just said. It's not a simple matter of Mr. Williams adopting or not adopting the person behind him. It's the person behind him echoing and adopting his admission. And by recording himself and that person on that video recording, Mr. Williams is essentially signing on to the sign on, if you will. He is agreeing with what that person is saying. They are synonymous. Snitching bitches is the last thing I think that someone said. And that is essentially the same as you come into court and tell the truth, you need to get killed. That's from me and YSL. And so, as I stated earlier, Your Honor, under 24-801 D2A, given the definition of statement as both an oral assertion and as a nonverbal conduct, the oral assertion qualifies as a statement that Mr. Williams is making, that a person who comes in and testifies should get killed from him and YSL, and the nonverbal conduct is recording himself and the person co-signing with him on medium.
Your Honor, the state in their argument just made a whole bunch of assumptions that there's no evidence to support. They just stated that Mr. Williams was hitting himself. I don't know how we can make that determination. They said that Mr. Williams decided to post it himself. I don't know how we can make that determination. And that's the whole point. We don't know these things. There's a lack of foundation.
In terms of what, sir?
Well, I mean, they just said that Mr. Williams taped himself. I'm not, they're saying Mr. Williams chose to post it on the internet. I'm not agreeing to that. So these are the foundational requirements that they're just kind of stating it as so, but I don't believe that that's been proven. So, and that's relevant to the issue of the adoptive admission part, or as you called it, I think we're talking about the same thing. You called it tacit admission, I call it adoptive admission. I think essentially we're talking about the same thing.
Sir, I'm sorry.
I will say this, I don't personally have any knowledge that this is on Mr. Williams' social media. I've looked, I cannot find it. If I'm wrong, I know the state didn't give it to me. Discovery like that, and I don't find it. And I'm not going to repeat myself, but we started this whole thing with there's no other person in the background except yay. Now other people are saying things in the background, but it shifted so much. And I just still think that the bottom line is somebody, the proponent of the evidence is the state of Georgia. Somebody has to come in and say, yeah, this wasn't altered, this is when it was made, and this is accurate, and we don't have that. What if this was made, Your Honor, in 2014? Just for instance.
But the challenge is that under current Georgia law, as it pertains to admissions by a party opponent, it's admissible without presentation of predicate or foundation. Unlike if you have a statement against interest, or unlike if you've got conspiratorial statements, there are a couple other things that need to be brought up. But this particular statement is being offered for the admission by a party opponent, and that's what the law provides under 24-8-801D2A.
Not really, because if you recall, it's posted, the state said, being offered as a statement also of a party co-conspirator, excuse me.
Okay, that's different. That would be under E.
Right.
And E requires different, but however, looking at E as well, conspiracy need not be charged in order for OCGA 24-8-801D2E to apply. For evidence to be admissible under this rule, the government must prove the existence of a conspiracy by a preponderance of the evidence. In considering whether a conspiracy exists was established for purposes of this rule, courts do not require the conspiracy to be proven prior to the admission of the evidence in question, but only that the conspiracy was proven at trial. So, but their primary purpose is under 801D2A.
Please correct me, but I believe the foundation is needed because remember how the state is using it is they're saying they charge it like this. They put it in the overt act. I think you said 26. I can't remember. I think you said that. They put it as a repost or posting by Mr. Garlington. It's not Mr. Garlington's statement. They're saying that it's Mr. Garlington's statement to warn people because they're in a conspiracy, so it's a co-conspirator statement. So I still believe that the statement originally by Mr. Williams has to be authenticated, as we've been discussing.
The law does, I don't think it does. I mean, there's nothing in here that says that statement has to be authenticated. It just says co-conspirator statements may be admitted when the prosecution shows by a preponderance of the evidence that a conspiracy existed, 2, that a conspiracy included the declarant and the defendant against whom the statement is offered, and 3, the statement was made during the course and in furtherance of the conspiracy. Where statements, however, admit participation in crime but do not evince an intent to commit further criminal activity, Rule 801D2E does not authorize their introduction. I would submit from the court's perspective that the statements could be considered by the jury for the other purposes of what your client said about people coming into court, making purported statements. So I believe that it would satisfy still the dictates of 801D2E, but remember the state's offering it under 801 for count 26, but also for the overt act under count 1.
So,
and I'll give that, we can hash out that when I charge the jury. Well, because it's going to depend upon some other things if we get to that point, and some other things that may develop in this case. So I'm not saying to you that we may not have a distinction between that, but at this point, I believe it'd be admissible.
okay, and listen, I respect your ruling, but that's why I found the Rodriguez case, because it discusses both 801D2A and 801D2E in the same C1 section, and they discuss specifically the authenticity under 901. That's why I thought it was a good case.
Okay, I understand. State have any further comment about that?
Your Honor, we believe 24-801 D2A is clear as it relates to foundational factors. And that along with the policy and rationale behind it makes the evidence that the state seeks to admit allowable, and we ask.
Okay. All right. I'm going to allow the state, allow the states 112 Bravo Bravo, the statement made on January 26th of 2015, over objection. And I'll make it a continuing objection as to all concerned. Okay. All right. Yes, sir.
Before the jury comes back in, can I ask about 3 minutes of what I'd like to address something?
Else?
Your ruling's done. You've already ruled. That's fine. We accept that. But I just want to address something that occurred with the bench that I want the court to address.
Sure.
And I just need about 3 or 4 minutes. I've got to say this because I've been sitting there after our conversations. Let me just preface it by saying, in any of our objections, whatever, you make a ruling. Sometimes we win, sometimes we lose, we move on. That's fine. If after your ruling, I've got a case that I want to bring to your attention, I say, Judge, reconsider your ruling based on this case, and you consider it, that's fine. If you don't want to consider it, that's fine too. But what I found objectionable, and I want the court to address with the state, is what happened at the bench earlier. There was an objection to the video, you made a ruling, we moved on. The state came back up and made representations to you. And they weren't representations based upon some new case law that they had found. There were representations, misrepresentations that were made directly to you, all of us standing there right there at the bench. She said something very, very fact specific in an attempt to get you to readdress the issue again. Madam Prosecutor said, I want you to listen to the 17-second video, because what you had based your ruling on was that the parties in the background couldn't be identified, right? And Madam Prosecutor said to you, and was not accurate, and I'm going to be charitable and say that she was disingenuous. What she said was, these people in the background, the only thing that you hear are people saying, yeah, yeah. That's it. When Mr. Steele corrected her and said that's not true, she said, Mrs. Steele is not accurate. What Mrs. Steele just told you is not true. The only thing you can hear in the background is yeah, yeah. And actually, when she stepped up there, it was in an attempt to act as though she didn't know what your ruling previously was, because their attempt was to go ahead and play the video at that time, despite your previous ruling. My point is this. After you decided to reconsider, you want to hear the video yourself, you had a chance to hear it. You had a chance to hear what we had already heard, what we knew it said, what they knew it said. And there are at least 5 or 6 different things on that video audio that were in contradiction of what Madam Prosecutor said. On God, snitching bitches, I'ma tell a lie on God. That's what I'm talking about. No back and forth with you, bro. Fuck nigga. I'm not just saying that for emphasis. I'm saying that because what she said to you was inaccurate. At some point, Your Honor, I'm asking you to, we've had this conversation about candor with the court over the course of the past number of weeks.
3.3.
Yeah, we've had that conversation about it. And when we step up to you and we make a representation, it ought to be candid and it ought to be truthful. And what she said, and look, if she wins the motion, ultimately she wins. But you don't do it by standing there 3 feet from you in your face and lying to the court. And that's what she did. And she knew what she was doing, and it's not right. You heard Mr. Steele. Mr. Steele said, Your Honor, I am willing to surrender my bar card and have her surrender her bar card if what she is saying is true. He wasn't wrong. She wasn't wrong. She was not candid with the court. And at some point, you've got to say to the parties, if I'd done that, I would expect you to say, Mr. Adams, don't do that again. Don't step up to me and lie to try and get me to rule or overrule something I've already ruled on. Don't do it again. You ought to say that to them. We're not playing games in this courtroom. These are these people's lives at stake. And like I said, sometimes you win a motion, sometimes you lose. But you don't get the court to address something or readdress something like that. That's all. Say something to them is all I'm requesting.
All right, sir.
Yes.
You may.
Your Honor, I would not have asked the court to listen to the 17-second video.
But what you did tell me, Ms. Love, wasn't the entirety of what was purportedly on states 112 Bravo. It did have other statements on it. It's different if you'd have told me, Judge, there are statements on there. Probably need to listen to them for yourself. Not just yeah.
Your Honor, my recollection, and I'm going to speak candidly because it's been.
I would hope there'd be nothing less than candor.
And Your Honor, that's what I've been pushing for all along. There have been times, as the court is aware, that we have been at the bench and misrepresentations, bald misrepresentations have been made, and the court has seen my reaction to them. I am the one that's constantly saying I have a duty of candor to the court.
All of you do. All of you do.
We do. And when Mr. Adams just read those series of things that he read, those half of what he said, I didn't catch. The part that I did catch and remember is the part I kept repeating just now, snitching bitches. And I didn't even recall that part was there. But what I did know was that the relevant portion and the relevant speaker was Mr. Williams. And Your Honor, I'd ask, we can do this in chambers or wherever, but Your Honor, I believe that certain requests and comments to the court have risen to a level of being not true motions or requests based on legal analyses, but more leveled specifically on a personal level, which I've attempted to stay away from. Whatever one's reason for doing what they do, if it's to better advocate for their client, that is fine, they're entitled.
Well, you're not entitled to do everything in whatever position you're from, be it the state or be it the defendants, because you have a overall right of candor, responsibility of candor to the court.
I agree, Your Honor.
There are certain things you just cannot do anyways. Zealous advocacy is one thing, but it should never be confused for misstatements or for anything else that's not less than candid to the court. I think both sides, you all are fighting very diligently and valiantly about your respective sides. And as I said a couple of days ago, what the public sees is there's friction between the state, the defense, and the court. That is natural, and it is good for the system because it shows that we are not in collusion with one another. Justice is what it will be, and whatever this jury will decide. But what I am going to just advise everyone to kind of relook is what you tell each other, what you tell me, because there have been times where I have not received, I would consider what is accurate information. Let me just put it that way. Okay. And I know, and I'm not trying to attribute, dishonesty to any party, but I have to rely, all courts have to rely upon counsel for their representation. So if you can't remember what it is, just tell me that. It's just like your duty to, when upon asked if there's any adverse position to this particular statute of law, you're required to tell me. I mean, I understand there's zealous advocacy, but I would also just remind everybody within the sound of my voice, professionalism really does matter to you all, and it matters to the court, and it matters to those that are watching this particular trial. yes, there have been some times that these proceedings are acrimonious, or intense. And the court has had to chastise both sides for things that have occurred. I don't have any personal issue. Remember what I told you. I tell the jury this when I charge them. The court has no interest in this case. My sole responsibility is to see that it is tried fairly as to both sides. So, and I maintain that in terms of I respect everybody in here as advocates, but I do need to have you just relook what you're saying to each other and to the court, because it really does make a difference in terms of our presentation before this jury, and then ultimately the jury is going to make a decision. So, look, all of you are very seasoned advocates. Even the newest lawyers in here have crossed that particular bridge at this point in time, given the length of time that we've been in this courtroom. So I can just tell you from everybody's perspective, Ms. Love and everyone else, Mr. Adams and all of you in here, that you all have jobs you have to do. The court understands that. But please remember at the end of the day, this won't be the last case you try with one another, and won't be the last issue that you try. So, but the court understands that you have a job to do. But understand that I have a job to do as well. I'm the referee. I have to determine what comes in and comes out in terms of my functions. So understand at the end of the day, we have that similar goal, but I understand you all have dissimilar objectives in terms of what the essencies are in terms of your roles and responsibilities. But don't ever forget your duty of care to the court, your duty of professionalism as advocates, and the duty of civility. It still applies in criminal cases as well. These defendants are presumed to be innocent, and they are innocent, and that's what this jury will ultimately decide. But we'll have to get there, and we'll make it, and they'll make a decision. Okay.
And Your Honor, I'm certain the court means until proven otherwise, they are presumed innocent until
they're innocent right now as we sit here. So, and until I charge the jury accordingly and otherwise, and the evidence is presented to them, well, evidence first and then charge them. But as to how this case goes.
Thank you, Your Honor. And thank you for addressing also the concern that I have, because that is my main concern, the level of civility and the level of personal commentary level that is, in my estimation, not necessary. And I appreciate the.
But that's everyone, everyone's can be accused of that at various times in this particular trial. I mean, I think that every issue that you have seen, Ms. Logan, anything that's been raised at this point in time, anyone who's sitting in this courtroom is probably violated at some point in time or another. However, let's just try and do better in terms of that. But just like I told you with evidence and the other things that need to be brought forth, let's try and do better with that, because certainly, as I mentioned earlier, I don't want to have the jury sitting here for long periods of time when we take up other business. So we need to plan accordingly. But I think you all could probably, do a better job at least forecasting what is going to be tendered or submitted so that we can minimize delay. So, I mean, to the extent you all started to do that, it seems to be working a little bit better, but we'll see how it goes. All right? All right, so I've ruled upon 112 Bravo. What I'd like to do is how much do you have left of your witness here?
I wanted to play the video, Your Honor.
So how much?
It was, I believe, 7
Okay, so how much more do you, just estimate, okay? Because I'm gonna double whatever you tell me. So how long do you think you'll have more of Sergeant Gaither?
After that, I will pass it.
All right. Councilors, I know you all have plenty across, but this will be the end of our work week, and we'll pick up on Monday.
Outside of the presence of the jury, but on the record, would you permit me to ask Investigator Gaither, when she returns on Monday, to bring all of her reports related to the Dexter Montgomery case?
Remember, she's retired from APD.
Okay, well,
Look,
I just want to report.
I can't, look, it's not a deposition, okay? It's not, okay? But I think she's going to be on the stand a little while for cross. So I would think that, and the state, have you asked her independently outside or?
I asked where her reports are. I didn't specifically ask her to bring them. If you'd allow me to walk out there, and I just don't want her to leave. I'd like her to bring her reports on Monday.
If she has them.
Well, if she has them, of course.
And would the court allow us to just finish up the last bit and then?
Why don't you ask her now so I can go ahead and do that, and then we'll know, and I can put that for purposes of the record. Just ask her that, and I'll take up something else right now. Okay.
Mr. Sharp did ask her outside in my presence.
I did ask her if she could bring reports on Monday.
She said she doesn't have them.
Okay. Well, just ask her, and we'll. Okay. All right. Where the dots are? Okay, all right. Or any of these other, oh, sorry.
Your Honor? Ms. Weaver is okay? Your Honor, is it okay? Just for the record, I just did step outside. Investigator Gaither was in the witness room. I think Mr. Brown came behind me. And I asked Investigator Gaither to please bring, to the extent that she's able, all her reports regarding the Dexter Montgomery case on Monday. And she indicated that she is no longer with APD, and she did not commit that she would bring them. And she said that she didn't think she would be able to bring them, but I did ask.
She didn't think what? I'm sorry, I didn't quite hear.
She indicated to me in that she would not be able to bring them because she's no longer with APD, but I did ask. I made that request.
Okay, does she have any reports?
She did not indicate that she has any reports.
Judge, the summation of that conversation was very brief. She indicated because she's no longer with APD, she doesn't have any reports. So she said, I can't bring anything. And she indicated her.
Okay, so you did satisfy yourself as to that, Mr. Sharp?
I did ask Investigator Gaither to bring her reports.
Okay. Are you satisfied with her well, did she tell you that because she's no longer with APD that she does not have any reports?
Yes.
Okay.
And I'm not satisfied with that, but I understand.
Okay, I understand that, but did you also ask her if she has any reports at home or anything that
I asked her to bring the report. She said she didn't have access to the reports.
Okay. Mr. Brown?
What she said.
She doesn't have any reports. So, all right, okay. Then you satisfied that inquiry, and it still is not acceptable to you, but that's fine.
Yes.
I'll note it for the record.
Thank you.
Okay. All right. Let's bring Sergeant Gaither back in. Okay. All right, Sergeant Ingram, summon our jurors, please, sir.
Mr. Jones, can I share an ability? Thank you.
These would be administrative days. All right, ladies and gentlemen, please be seated. All right, thank you, Sergeant Ingram. All right, Ms. Love, you may proceed, madam.
Thank you, Your Honor. Permission to publish State's Exhibit 112, Bravo, Bravo.
Any further objection that has otherwise been not noted or for purpose of the record? All right, I'm going to admit State's 112, Bravo, Bravo over objection with the caveats that the court has already ruled upon, and it may be published as you see fit.
Thank you, Your Honor.
So, nigga, a lot of they mama, a lot of they kids, a lot of they brothers and sisters didn't get ready in the courtroom and tell the God that is true.
Fuck, nigga.
Don't get it. Y'all niggas need to get fucking killed, bro.
You snitching bitches.
From me and YSL.
Sergeant Gaither, is that the video that you were able to capture from the account that you spoke of earlier?
Yes.
Thank you. Your Honor, at this time, I'll pass it.
All right, ladies and gentlemen, given the fact that it is Wednesday at 5:05 and we've had this was the work week that I promised you. At this point, we're going to recess for today. And since it's a natural stopping point, we'll go ahead and we'll reconvene on Monday. So, retired Detective Gaither, madam, can you come back Monday morning, the 29th of April for 8:30, please?
Yes, sir.
Okay, all right. Remember not to discuss your testimony with anybody except the attorneys in this case.
Yes, sir.
We'll see you on Monday. All right, ladies and gentlemen of the jury, any ministerial inquiry of me at this point? Okay. Before I give you your admonitions and ask this question again, we will have administrative days tomorrow and Friday. And I have signed the order effective as of tomorrow, so you will get remuneration for tomorrow and Friday since I've designated them as administrative days. Okay. All right. We will reconvene on Monday, the 29th. I'd like you all to be here as close to 8:30 as you can for our anticipated 9 o'clock start time on Monday. Okay. And we will work on Monday pretty much all day. Okay, kind of similar to what we had today. All right, ladies and gentlemen, any other ministerial inquiry at this point in time of me? All right, let's go through your admonitions at this point in time, okay? When you leave, Put your notepads in the basket. Do not discuss this case amongst yourselves in onesies and twosies, or as you go to whatever means of conveyance to get to your homes within our great county. Do not otherwise recap or handicap the testimony that you've heard thus far in this courtroom. Remember, you cannot consider this case until it's properly presented before you, and the court gives you the instructions on how you're to consider it at the time and manner and place that when that time comes. So remember not to let anybody discuss this case within your presence and hearing. If you should encounter anybody, either third party or anybody should reach out to you or speak this in your presence, myself and Sergeant Ingram would need to know immediately. Please do not go into any third-party sites. Do not try to do any extra research, because remember I told you you can only consider what's presented in the four walls of this courtroom. Do not go by and visit any of the scenes that may be depicted or may have been shown to you in this courtroom. You are not authorized to do that. That would be a violation of this court's admonitions. And remember, as you sit back there, I told you this before earlier, but I'll say it again, don't discuss whatever's going on in the courtroom at this point. You cannot do that as well, and that also would be a violation. Ladies and gentlemen, again, thank you for your patience that you've given us and will continue to give us. And unless you have any other inquiry of me, bless you. We will see you on Monday, the 29th of April, 8:30 for an anticipated 9 o'clock start time or thereafter, okay? All right, so have a nice long weekend, and we will see you on bless you, on Monday, okay? All right, all rise. All right, ladies and gentlemen, please be seated. Our jury has left us. All right, counsels, is there anything else the court needs to take up before I recess you all for until Monday, the 29th at 8:30? You all need to be here close between 8:30 and 8:45. You all could be here so I can take up anything that may be required of the court before our juries are all assembled. Is there anything else I need to take up at this point in time? Related? All right, Mr. Sharp, you got that look. You got that look. Okay, you got that look like you'd like to ask me something else, sir.
No, I'm good for now. Thank you.
Okay, Mr. Steele, anything, sir?
No, sir.
Okay, all right. Anybody else? Mr. Vach, you trying to get up or something like that, or what? Okay. From what? All right, okay. All right. Councils, I'll see you on Monday, the 29th, okay? All right, we're in recess.
Ladies and gentlemen, good evening. Good evening. Good evening. Good evening. Ladies and gentlemen, good evening. Good evening. Good evening. Okay. Looks like we are still live here. Okay, ladies and gentlemen, good evening. All right, let's see where we at here. We are going to end this live. Thank you for tuning in. With that said, good night.